All right, good morning and welcome to the August 14th, 2025 joint meeting of the Board of Trustees and the Committee of Bar Examiners. Going to call this meeting to order. As a reminder, this meeting is being recorded. This is a unique meeting for us both, with both the Board of Trustees and the Committee of Bar Examiners together. However, please also note that certain agenda items are reserved exclusively for Board of Trustees consideration and action as indicated in the posted agenda. To start things off, we'll go ahead and take roll. And Madam Secretary, if you could call roll for the Board of Trustees, please.
Barahona,
Present.
Buenaventura,
Present.
Cisneros,
Present.
Good, not present. Gore, not present. Grande,
Present.
Harrison,
Present.
User, not present. Sowell,
Present.
Stallings,
Present.
Stevens, not present. Tony,
Present.
Trejo.
Present.
Chair, you have a quorum.
Great. I'm going to turn it over to CBE Chair Alex Chan.
Thank you, Chair Stallings. Ms. McFarland, please also do same and take roll for the full CBE.
Bolton,
Present.
Cow, not present. Chan,
Present.
Gongora,
Present.
Kaplan, not present. Kramer,
Present.
Lawrence, not present. Lynn, not present. Macy-Walla,
Present.
Montgomery, not present. Peak,
Reporting here.
Silva Guzman,
Present.
Smith,
Present.
Reyna, not present. Reyes,
Here.
Yokelson,
Present.
we have a quorum.
Thank you. Back to you, Chair Stallings.
All right, thank you. Next on the agenda is a call for public comment. Before we begin public comment, I'd like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the board is the state bar's governing body and responsible for exercising oversight of the state bar. The Committee of Bar Examiners exercise oversight on admissions matters, including the California Bar Exam, the first-year law students exam, moral character applications, and law school regulation. State bar staff will attempt to call members of the public in the order they appear in the attendee pool. And I would ask, if you are in the meeting right now and wish to make public comment, please do so by clicking the hand raise icon. This is a function for virtually raising your hand. It's the hand icon and should appear at the bottom center of your screen. So please click that now to give us an idea of how many public comments we have. We will attempt to call on you in the order that hands are raised. If you're participating via phone, you may virtually raise your hand by pressing *9. Doing so will alert staff that you'd like to make comment. State bar staff will call on you and open your microphone so you can address the board. For those of you participating from a noticed location, please alert the state bar staff member present in the room that you would like to make comment. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. Because of the length of today's agenda and the very important items that we are discussing, we are going to limit, I am limiting the public comment period to 2 minutes per individual, unless noted otherwise. And this 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. I would just ask all public commenters to please respect that 2 minutes. We have a lot of items to get through and a lot of trustees and CBE members to be heard. We have significant public comment prior to today's meeting from the many meetings that we have conducted in the wake of the February 2025 bar exam. So rest assured that we have heard your voice. We continue to hear your voice, but we also need to get through this meeting in an efficient manner. I would like to keep public comments to 1 hour, as we only have approximately 4 hours set aside for this meeting and many items, as I mentioned, to get through. If it becomes necessary, I will entertain a motion to suspend the rules to shorten the public comment period to 1 hour. All right. I think I heard that there was a public commenter at one of our noticed locations who'd like to go first? All right, so I'm going to turn it over to, not sure who's in that room.
Justice Macy Walla has the public member in her office.
Great, thank you. All right, sir, your time begins now. You can proceed.
Good morning. My name is Kai On from Sacramento. On July 18, I went to San Francisco State Bar headquarters submitting a request to Board of Trustees. I request Board of Trustees meeting to discuss why State Bar dismissed my complaint about Attorney General and Sacramento District Attorney didn't investigate. Sacramento Police Department and Sacramento DA office provide me fake and forgery document for my father's death. They commit obstruction of justice. State Bar case number 25-0-12611 and 12612. I have protests at Attorney General headquarters and Sacramento Superior Court and Sacramento District Attorney Office. There's no reason Mr. Robert Bonter and Mr. Tiano don't know my complaint. From March this year, I have been asking Board of Trustees to look into my complaint. Some political power is blocking me to find out how and who killed my father. I have submitted all the evidence to Board of Trustees before. Chair, Mr. Stallings, could you please provide response for my request?
All right, sir, you have 30 seconds left. Is there anything else that you wish to say?
No, but because I have been request Board of Trustees to look into my complaint. So, Mr. Stallings, do you have any response to my request?
Sir, this specific item is not agendized, so I'm not going to make comment on that, but I will direct staff to look at that issue and then to get in contact with you for any future steps. So thank you for your public comments. Sorry to hear about the loss of your father.
Thank you, sir.
All right, thank you, sir. All right, well, I'll go next to the Los Angeles office. Any public commenters there?
There are none here.
Going to San Francisco State Bar office. Any public commenters there?
There are none here.
All right, and then I'll just go through, if there are any trustees from a notice location who have public commenters, just raise your hand at this point. Or a committee of bar examiners, please raise your hand. Okay, seeing no hands, Madam Secretary, can we go to the sign up list, please?
We have 5 signups today, and currently I do see 6 raised hands. First, we will start with Benjamin Cohn. Your mic has been enabled.
Thank you. I would like to first start with the item about the next gen bar exam and the other NCBE products. I think that the State Bar should not pivot to those items. It is important that the remote testing be available as a standard condition. I did want to clarify, since there was a lot of discussion at the last meeting, that avoiding the NCB or making this declaration was important for accessibility for people with disabilities. And that's true. Remote testing is so important, but the obligation to do remote testing remains even if the NCBE is used in that context. There's a lot of improved accessibility for a lot of other reasons that would occur if it could be a standard condition, including maybe for the ease of the process to get approved for the disabilities, but then also because it's standard, and then a lot of the other things. But the NCBE has very explicitly confirmed to me since the last meeting that they do not prohibit jurisdictions from considering remote testing as a testing accommodation for even just the MBE, let alone your own materials. That is a policy that was attributed to them in a lot of State Bar FAQs that they have informed me was incorrect. So you do need to it wouldn't have mattered even if they did have that policy because it would be unlawful, but you do need to, especially with that, entertain remote testing as a testing accommodation, even for the MBE. That said, remote testing should be a standard condition for any applicant who wants it. And for that reason, a California-specific exam materials that uses the Kaplan questions you've already paid for is very important to proceed with and to give the 2-year notice that the Senate has very improperly put in the bill if you can't get that taken out. Secondarily, I wanted to speak out against the fee increases because I do know you need to raise more money under the circumstances, but the applicants should not be the first go-to source of that money. Measure Learning caused all the problems with the February 2025 bar exam, not the remote testing and not the Kaplan questions. They are going to have to pay damages, hopefully. You should do financing with the general fund or the state or someone or even a bank against that future recovery instead of passing it to applicants now. And if you can't raise it enough that way, then a subsidy should be sought from the legislature if the exam must continue in this form. Thank you.
Thank you. Next commenter, please.
Next, we have Ray Hayden. Your mic has been enabled.
All right, so first things first, I'm going to agree with everything that Benjamin Cohen just said, and I consider him to be a subject matter expert specifically on accommodations and things of that nature. My public agreement with some things was really in part and not totally against the issues that Benjamin Cohen's working on. Now, my next thing I want to say is that there was that credit for the February exam due to the snafu there, and I was one of the people that would be getting that credit. That needs to be attached to the person, not a time limit on which exam they take, because I'm not going to go to California in person for an in-person exam because they fleece me. I can afford it, but they fleece me, and I don't like getting ripped off to my face. Okay, it's really bad. So California, the hotels, the food, transportation, everything just cranks up for those couple of days during the exam, and I'm not going to do it. So, but have the remote exam, and like I promised you before, and I followed through on, if you have it remote, I can fail it 100 times. I'll still take it, but I'm not going to go get fleeced from California again. Other thing is for Alex Chen and Trustee Harrison, because I've been watching you all through the Blue Ribbon Commission and all that. The remote exams are the way to go. They will save you just a ton of cash. You can actually lower all of the fees and make more money, and administration or admissions is supposed to be self-supporting in the first place. I guarantee you that will be able to happen. You have to fix the remote exam. You have to fix the ability to be able to do that, and your costs should drop dramatically in that aspect. Also, one last thing about that. Yeah, it just saves tons of money, time, energy, frustration, aggravation, and things of that nature. And I think there was just attaching the credit to the people who have it coming to them and not deadline that on an exam. Thank you very much for your time. Have a great meeting.
Thank you.
Next, we have Jewel Sarkar. Your mic has been enabled.
Thank you. Good morning. My name is Jewel Sarkar. I'm here today to urge the Board of Trustees and the Committee of Bar Examiners to reject all of the options that are presented by the admissions office staff for increasing the fees for applicants until you have the factually correct information that you need to support these fee increases. And I also ask that the bar reject any further cooperation with the National Conference of Bar Examiners. Over the past few years, the admissions office staff have presented you with bar exam cost analyses that show that the expense of the bar exam were under $10 million for those specific years. But when they were presenting an opportunity to take more fees from applicants, the Chief of Accountability changed that claim to say that the bar exam expenses were actually 26 million without an explanation or breakdown, urging you to increase the fees for applicants and claiming that approval was immediately needed, not giving any explanation or breakdown for that number. Those exam fee increases were approved, and so those same employees were never held accountable for those claims. Instead, they were promoted in some of those cases. Because of this, they knew that withholding material information from the board, the committee, and the executive director and the public that would continue to be consistently rewarded. And so they told you and the public that they were hiring Kaplan to fulfill the role of the NCBE at a cheaper price, knowing that they were not approved to use ChatGPT to develop exam questions. They didn't tell you that. They wanted everyone to have the false impression that the exam was being professionally developed and withheld this information from you and from the public until months after the exam. Because again, those same employees were never held accountable for their conduct and their statements. They are presenting yet another opportunity today to take more fees from applicants and expecting to be rewarded again, which is unsurprising. It's in their best interest to continue providing a costly and faulty exam. And since no one has asked them to reconcile the numbers that they've presented to you that vary by over tens of millions of dollars in a given year, and no one has asked them where that money is going, they stand only to be rewarded by continuing
Thank
to
you
tell
for
you
your public
that the
comment, but your time has concluded. Next, we have LAAC trainings. Your mic has been enabled.
I'm sorry about that. I must be not logged in. But good morning, trustees and committee members. Thank you for the opportunity to speak today. My name is Rianne Pacheco. I am with the Legal Aid Association of California. I would like to address action item 2.6, the 2025 Provisional Licensure Program fee. Legal aid organizations will be the ones to suffer from these steep fees. Not only will it deter my organizations from participating in the PLP, but as a result, the community will miss out on a pool of diverse and competent lawyers. Legal aid organizations happily commit their own resources to support PLLs, but approving these fees will be a significant financial barrier, and this is discouraging to legal service providers. We appreciate the bar's analysis on the costs that will come with running the program, but with these fees, we are confident that you will see a significant decrease in enrollment and therefore won't make revenue either way. We understand that these operational costs have costs, but this is an unexpected considerable jump that we would like to learn more about. As you know, legal aid organizations are currently facing unprecedented funding cuts, and I have seen ending of longstanding programs and layoffs, all while high demand for their services. PLLs have proven for many years now to be useful and welcome additions to the community to help fulfill the legal needs of low-income Californians. It is critical that PLLs continue to be able to serve their communities at legal aid nonprofits, and lowering the fees will be the way to do that. We appreciate the State Bar and the trustees in this committee's commitment to the PLP, and LAC will continue to support this initiative, but we strongly recommend lowering the fees for all PLLs, especially those working at legal aid organizations. We believe the fees should be on par with a PTLS fee, or at the very least, the standard attorney licensing fee. If any option must be selected, then we cautiously recommend option 3 with a lower IOLTA fee. Thank you very much for your time.
Thank you for your public comment. Next, we have 1085. Your mic has been enabled.
Hey, can you hear me?
Yes, we can.
Oh, great. Good morning, everyone. Briefly, I just want to mention two things. One, with the third party HUMPRO, I did receive a call and an interview from that third party company, and unfortunately, I was told that I was not able to show any of my evidence that I had. All of the communication back and forth between the proctor and I, also pictures of my screen being locked out for a number of times. And the representative told me that I have to submit all of those materials to the bar. Well, all of those materials were sent to the bar. I don't remember the exact date, but we were given like 24 hours to get our package into the bar. And like others, I do not live in California. I am from Illinois. So in order to get a package there guaranteed, I had some of my friends who live there, I had them to print it out and to send it to your office. The cost of all of this was over $300. Not only did I have my package sent by FedEx, but I had my package sent from Illinois to California overnight by UPS. So I used two services. The office did acknowledge that they received it, but I was very surprised that the company that you hired would not even allow me to show them all of the evidence and proof that I had that I was locked out.
Thank you for your public comment, but your time has concluded. Next, we have Claire. Your mic has been enabled.
Morning. This is Claire Solot from the Legal Service Funders Network, and I am joining in the comments that LAC previously provided with regards to the proposed fees for the PLL program. The LSFN over the last 6 years has had more than 140 fellows participate in our program. Many were PLLs as our initial cohort started in 2020 as a result of the COVID pandemic. At that point, the fee ranged from $50 to $75 and was similar to the PTLS fee. The proposed 3 options for the 2025 PLL fee is, as you know, significantly higher. There is no explanation besides the cost of staff as to why this fee has gone up so dramatically. We would appreciate transparency with regards to the elements that require the fee to go up more than 10, 20, 30 times. The math is beyond understanding. In addition, the 20% volunteer figure being used sends the wrong message to employers that the state bar is in fact supporting the idea that PLLs would not be paid. It also conflicts with the tremendous and positive efforts the state bar has made recently to provide stipends through their 2L fellowship. Lastly, it increased the costs to those who are paying a fee. We advocate that the fee be reduced for public interest PLLs, not just for IOLTA organizations, but for all PLLs that are working at legal aid organizations. As LAC recently just commented, the need for public interest attorneys is at an all-time high. The State Bar's 2024 Justice Report confirms this, and we are in a situation where any obstacle to PLLs at public interest firms doesn't make sense. Thank you so much.
Thank you for your public comment. Chair Stallings, I do not see any more raised hands in the attendee list.
Great, thank you. This will now conclude the public comment period. Appreciate everybody who has submitted written comments and who has been attending a majority of our meetings this year. All right, I want to go to our open session agenda. And first is the chair's report. I will succinctly say that this really is a historic meeting between both the Committee of Bar Examiners and the Board of Trustees. Certainly both of our bodies have been wrestling with questions raised, policy issues put at the forefront of everybody's attention. And, you know, it really deals with the February bar exam, but also provides us an opportunity to continue to work towards a better organization, a better structure, and a better end product that we can offer to those who wish to become licensees in California. So we've embraced this challenge. I know staff has worked incredibly hard to address the concerns of members of the public, test takers, our stakeholders in the legislature, the Supreme Court, and our various sub-entities. And so I think that this meeting is an excellent opportunity for both of our entities to have a discussion on issues that have far-reaching implications and decisions that need to be timely made given some legislative direction that we are receiving now. So just in that spirit, I know that everybody here has been in numerous meetings, has, displayed the utmost of professionalism and conciseness. And I think those are going to be even more imperative in today's meeting as we tackle some interesting issues and have, if everybody was in attendance, over 30 individuals who might wish to give comments. So I just ask that you keep your comments in mind, or your comments just take into account how many individuals may wish to be heard on these issues. But I do look forward to a robust conversation, and have really enjoyed working closely with Chair Chan over at CVE during the past half year. It seems like almost a full year. And it has been a pleasure to get to know him a little bit better. So I want to hand things over to him for his chair of the Committee of Bar Examiners report. Oh, you're on mute, Alex.
Thank you. I just want to say thank you as well. I echo your comments, Chair Stallings. This joint meeting is really a significant and monumental moment for both the CBE and the board. It is, to my knowledge, I think the first time all members from both entities have come together in a single forum, not just to listen to updates, but really to engage in meaningful and policy-driven dialogue that will help shape the future of attorney licensure and admissions in California. And also, I want to take a moment to recognize how valuable this joint meeting is. True that the CBE and the board are distinct bodies with distinct roles. We have always operated within a shared public mission. And in that sense, we are not really two separate bodies with overlapping responsibilities. But in my view, we are really partners in ensuring that the path to becoming a lawyer in California is consistent with the Supreme Court's directives, which is the very judicial entity under which the CBE faithfully serves. And this meeting gives us a unique opportunity to share innovative thinking, to align our short and long-term goals, and also really to provide clarity to our complementary roles so that the State Bar can function even more effectively. Now, as we have seen from the agenda, we are covering major issues that really go to the heart of public trust in the admissions process. And these topics are complex, they are consequential, and they really deserve collective insights and scrutiny of both the CBE and the board. So make no mistake, this meeting is, or at least sets a very healthy precedent, and it signals to the public and the legal profession that transparency, collaboration, and accountability are not just buzzwords, and they're really built into how the State Bar of California operates. And that's something I personally am very proud of. With that, I'm confident that by working with you, Chair Stallings, and the board as a whole closely, the CBE will continue to be able to uphold our obligations to the Supreme Court, to our profession, and to the public. With that, I will pass the baton back to you, Chair Stallings.
All right, well said, and could not agree more. Thank you for those comments. We will go to our first item of business, which is item 2.1. This is an admissions update regarding the February and July 2025 bar exam administration. And this is being presented by Program Director Audrey Ching. So welcome, Audrey.
Thank you so much. Let me share my screen. My PowerPoint is pretty brief. I know we have, like everyone's saying, a very packed agenda. So one moment.
I'd like to note for the record that Kareem Gangora has to step away for 20 minutes.
Okay, so I'm presenting an update about February and July to both bodies today. So February, the Human Resources Research Organization, HUMRO, did conclude the part of their review related to the scoring of the February 2025 bar exam. So they did a scoring review of unsuccessful applicants in July. The review was comprehensive, looking at all the scoring processes, including all the emails and messages sent through the applicant portal about grading reconsideration. As a result, the major finding was that 31 unsuccessful applicants had notes that were not fully exported during grading. Those notes were exported, sent to the grading team, and only 1 out of the 31 had a score change, but it did not result in changing to pass. That person has received their updated score, and their full set of notes is now in their applicant file. There were no other scoring errors identified. During this time, but separately, we were able to also export annotation notes on the file in library. When applicants took the February exam, the file in library for the performance test opened in another tab. And on that tab, you could make basically little sticky notes, little annotation notes. We were able to export those as well. Sent those to the grading team during this time, reviewed by our graders who were grading each of those questions where they were those notes, which was the performance test. And 3 applicants had scores that changed from fail to pass. Those applicants were notified by me on July 18th. But that was separate from what HMRA was doing to review scoring. Moving to July, overall, the administration of the July exam proceeded as planned. No major disruptions, no systemic problems, just the typical one-off issues that we have every in-person exam at our sites. As needed, the staff, the applicants, the proctors responded to those unique situations. Just some high-level overview. We had day 1 when we administer the essays and performance tests, minor proctor adjustments. So it happens every exam, no shows. We need people in different kinds of proctor jobs. So we need to reassign, we need to elevate some to different roles. And sometimes we move proctors from the roles they were assigned to other parts of the floor. Applicant behavior issues, people deciding they want to sit in a different seat, or if their laptop wasn't working, they moved to the handwriting section. Academic integrity issues at our accommodated sites, folks asking about their accommodation, exam day logistics, and then on our side, notes for the next exam. When you get to a site and you unpack everything, some of those things were missed. So some of the stopwatches didn't have working batteries that we had to get batteries for the day before, missing some paper, some Post-it notes, things like that on our side. And then a couple technical things, as you might recall, when you do the test in person with ExamSoft, you don't upload your file until you connect to internet later. And some of the applicants had trouble connecting to internet during breaks or after the exam on day 1 and were not able to upload their answer files. On day 2, that's the MBE day, so that brings a lot of Scantron-related errors. So you can imagine folks bubbling in, that causes errors. And sometimes when you miss bubble and you erase sort of vigorously, you rip the Scantron. So we have to give new Scantrons, attach the ones with errors, all sorts of those kinds of Scantron issues across our sites. Questions about accommodations, asking to waive granted accommodations or asking day of for more accommodations. We did have a medical emergency. That does happen every bar exam and not just in our jurisdiction. Again, allegations of academic integrity issues, and then more proctor issues, some dismissals, and some knowledge and behavior issues. The exam continued for many days for those with the extra time. We did have on the 3rd day earthquake in Southern California that was felt but didn't disrupt testing at all. And then just that continued support around accommodations, logistics, questions that you might expect as the test continued. By the numbers, so the total we anticipated for the July exam was 8,328. We had 574 withdrawals or no-shows. So 7,741 attended across the state. Out of that number, 1,037 were accommodated applicants. We recruited on the Office of Admissions side, we recruited 1,318 proctors and had to use 245 Robert Half temp agency hires to fill in any gaps. And that is my brief update. Any questions?
All right, any questions, comments?
I had a quick question. Ashley Silva Guzman, Committee of Bar Examiners. We, I think, also maybe saw the news recently regarding a medical emergency, I think in New York. I wanted to just address or ask if we have preset or pre-planned approaches or methods that we use at the test sites for when we do have these medical emergencies, since we do seem to have them every testing.
We do, and it's a high stress environment. So there are things that happen, as you all remember who took the bar exam, that can cause a lot of different, it can exacerbate existing problems, it can cause new problems, anxiety related problems. So yes, we do have procedures on site. We have our staff members in charge who will enact those procedures. And the most likely thing we do, which happened in this instance, is call for the ambulance. And that person was checked out and went to the hospital, ended up coming back. But yes, we do.
Thank you.
Thank you. Anybody else? And for members in the Los Angeles and San Francisco office, it's hard for me to see if anybody's raising their hand. So just go ahead and speak into the microphone if you have any questions.
There's nothing in LA, Brandon.
All right. Thank you, Alan. Okay. All right. Seeing no hands, going once, going twice. Thank you so much to staff. I know that there was a massive investment in staff resources, time, energy, working around the clock. Donna, I'm looking at you. Just with, I know I'd get emails, 1, 2 o'clock in the morning. So I know that that you and your team just moved heaven and earth to make sure that July went as smoothly as possible. I've received a lot of feedback from bar applicants who sat for the bar, some of which sat for the February bar and then the July. And there was definitely a desire to have some sort of remote testing option, citing to, being in a large crowd compared to a smaller cohort and, some of those concerns, but just really pleased with the work of staff, really pleased with the work of CBE and Board of Trustees to ensure that July went as smoothly as possible. And so best of luck to all to the applicants. This concludes 2.1. Going to hand 2.2 over to CBE Chair Chan. We're going to kind of do a stair-step handling of these items. So take us away, Alex.
Thanks, Chair Stallings. Next on the agenda is is item 2.2, which is the discussion and action on recommendation to the Supreme Court relating to the court's proposed amendments to Title IX of the California Rules of the Court. I believe we have a presentation by Ms. Donna Hertzkowitz. Donna, can you please take it away?
Yes, thank you. And there we go. Devin is sharing the screen for me. Thank you. And as she's getting that set up finally, I just wanted to thank you, Brandon, for acknowledging staff. I want to be clear that any emails I sent you I was only able to do that because staff are the ones who are doing the work. So thanks to the team in admissions who were really able to impressively get all of the facilities that we needed. The proctors, Audrey and I tried to convince staff that we were not going to be able to get that many proctors, and they told us we were wrong, and they proved themselves right, and they proved us wrong. So the staff the congratulations all goes to staff on that. Moving on now, as we said, to item 2.2, which is a recommendation to the Supreme Court regarding the court's proposed revisions to Title IX of the California Rules of Court. As the members are aware, in late May, the Supreme Court proposed a series of amendments to Title IX of the California Rules of Court. The revisions largely, though not entirely, addressed admissions-related matters and are intended to bring clarity to the roles and responsibilities of the board, CBE, and the Supreme Court. Clarity, as you'll recall, that you all asked for as we were trying to get our hands around who was responsible for various decisions, who had the authority to make various decisions in the aftermath of the February 2025 bar exam. The rule revisions also include some small amendments to rules relating to regulation and discipline of attorneys, and we will mention those very briefly at the end of this presentation. At the direction of the court, the rules were sent out for a 45-day public comment period, and we received comments from 25 commenters. You'll see in the staff report sort of a breakdown of how those 25 comments came in. If you can move to the next slide. So our goal for today is to develop final recommendations to present to the Supreme Court on the admissions related rule amendments to the Title IX proposal, and to delegate to staff in consultation with the board chair and vice chair to develop recommendations related to the regulation and discipline rule related amendments in the proposal. The staff report and the attachments that are posted for today's meeting, including this slide deck, include a description of the proposed revisions organized into 5 categories. They also include any prior input that was provided by CBE when we had a preliminary discussion of this at the CBE's June 20th meeting, as well as input that was provided by the board when the board had their preliminary discussion at its July 3rd meeting. And finally, the slides and the attachments and all of the materials also discuss the public comments that were received during the 45-day public comment period. And here's the finally, staff recommendations. To help us move through this item today, I'm going to focus on a high-level summary of what's incorporated in each categorization or each grouping of the rule areas as it's laid out in the staff report. And then turn to the substantive staff recommendations, which were derived from all of those inputs that I previously mentioned, board and CBE, prior discussions, and public comment. Additional staff recommended changes are set forth in the red line that is in attachment D to your materials. It's essentially a red line of the red line that the Supreme Court provided in setting out its proposed rules. Next slide. So the first categorization of rule changes dealt with the general oversight and admissions. This includes changes to rules 9.3a and 9.5a of the rules of court, narrowing the state bar rules that require approval from the Supreme Court. Current rules require all state bar rules adopted by CBE pertaining to the admission to practice law be approved by the Supreme Court. The change would be that the change proposed in 9.5 says that changes that are recommended by the committee to the prerequisites to be certified for admission would need to be approved by the Supreme Court. This does seem to narrow the rules that the court would need to approve, limiting, for example, approval of rules related to testing accommodations or special admissions programs or otherwise identified on this slide. Next slide. So moving to the staff recommendation, staff is not recommending any change to the language that is proposed. However, we are recommending seeking guidance from the Supreme Court to remove any ambiguity about which rule changes would in fact need to be submitted to the court in the future, just so we've got clarity as we move forward, as we are developing amendments to any rule package, just making sure that there isn't a question at the end of the day where these rules go next, if they are finally adopted by board action or if they need to go to the Supreme Court. I'm going to stop here before moving to the next grouping of rules, as I plan to do as we go through each of these groupings, to see if there are any questions or comments with regard to the staff recommendation or alternatives proposed.
Any comments from the board or members of the CBE? Seeing none, Donna, you may continue.
Thank you. So next slide, please. So the next grouping of rules deal with oversight and development of the bar exam. These rule revisions add quite a lot of specificity to the responsibilities of the Committee of Bar Examiners in administering the bar exam. The rules also specify board oversight responsibilities for many of these same areas, or all of these same areas, creating 2 levels of review and approval. For example, for determination of the vendor to provide bar exam questions, 2 levels of review and approval for the development of standards to use a third-party vendor to administer and or proctor the bar exam, for developing standards, not rules, but standards for testing accommodations, and for overseeing the grading process. So infusing the additional responsibility with the board in some of these instances where the board had not previously had responsibility in these areas. Also, the changes in this area provide that in proposing any changes relating to each of these items that I just talked about, as well as the mode, format, scope, content, and topics of the bar exam, the rule as proposed would require a cost-benefit analysis to be developed with the rule setting for specified elements of that cost-benefit analysis. The amendments further require the Supreme Court to approve any changes to the bar exam that require substantial modification to the training or preparation required for passage. Next slide, please. So based on prior board and CBE input, as well as public comment, which is summarized here on this slide, staff recommend that staff recommend adopting a recommendation from public comment that any contracts with a third-party vendor for exam development include conflicts clause to ensure that there is not a conflict of interest, that the vendor does not have a conflict of interest. This is standard operating procedure for us, certainly, but for clarity, staff recommend including that into the language of the rule. Staff also recommend adopting the recommendation that came from several law school representatives that specifically detail the requirement to consult with law school stakeholders in areas of their expertise to get input from them as we are developing the new exam. Staff are recommending eliminating the language that is proposed that would require the Committee of Bar Examiners to develop and maintain standards regarding bar examination testing accommodations, subject to review and approval by the Board of Trustees. The staff report goes into the reasons for this, but in short, this deals with standards, not rules. As in the past couple of years, the staff and the Committee of Bar Examiners have spent a lot of time working on changes to the testing accommodation rules. And the first iteration of these rules, the rules were pretty high level. And what we included was a framework or standards for how we would implement the rules. We received considerable negative public comment about that, arguing that there should not be standalone standards, but rather those standards needed to be included in the rules because the rules do have to go out for public comment, do have to get approval by the Committee of Bar Examiners, do have to go through the board. Because of that process, there was significant concern about the adoption of anything outside of the rules. And as a result, staff are recommending taking that language out about developing standards for administering the testing accommodations. The staff recommendation also, and again, this is all reflected in item in attachment D in the rule proposal, but the staff are recommending focusing when the cost benefit analysis is required. The current language would require the cost benefit analysis to be provided, to be developed with regard to any of those changes that we previously discussed on the last slide, the selection of the vendor for question development, for setting standards, for sorry, I'm trying to get the exact language here. Maintaining and publishing qualification standards for the selection of panelists and subject matter experts for content validation panels, for overseeing the grading process, and staff does not believe that all of those things lend themselves to a cost-benefit analysis. Cost-benefit analysis would seem to be, would lend itself to the recommendation of any change to the services of third-party vendors that are used to prepare bar exam questions, which are set forth in paragraph A of paragraph 1 of Rule 9.6, subdivision A, and also in subdivision 3, paragraph 3, which requires CBE to develop and maintain, and the language staff is suggesting as a rubric for assessing the ability of third-party vendors to administer or proctor the exam. These are the types of things that seem to lend themselves to the cost-benefit analysis, whereas developing and maintaining and publishing qualification standards for content validation panelists and subject matter experts, in our view, do not lend themselves to that. We want to provide clarity on which of the things would require the cost-benefit analysis, and making sure that we are not expending effort and resources to develop a cost-benefit analysis when it's not really relevant. The staff recommendations also would delete the board role in oversight of the grading process. This is something that has historically been within the authority of the Committee of Bar Examiners. As the Board of Trustees will recall, with the issues coming out of the February exam, recommendations about scoring adjustments went straight from the Committee of Bar Examiners to the Supreme Court. These things that are certainly having to do with scoring adjustments are very time sensitive, and we would not want to impact the ability to make those changes quickly and to be able to implement those. And we don't think that that adding the board into that process is necessary. Finally, not mentioned on this slide, one of the CBE members had mentioned to us that there was a typo in that staff had introduced in the language in Rule 9.6B with regard to the cost-benefit analysis. Staff had indicated that the cost-benefit analysis shall be presented to the Board of Trustees, and then it says, and if the Supreme Court. So that should read, the cost-benefit analysis shall be presented to the Board of Trustees, and if appropriate, the Supreme Court. And so that, so we're recommending that change as well. So with that, I will, again, as I did last time, stop here before moving on to the next grouping of rules to open it up for discussion, see if there are questions or any comments with regard to the recommendations, any additional recommendations that the committee or the board would like to discuss.
Donna, it's Paul Kramer. I've got two questions, maybe three. So I had two other typos that I identified to you folks this week. Are you taking care of those as well?
Yes, and we'll take care of those in order, and you will also see a change to the resolution when we get to the resolution that would allow staff to identify if there are other technical, non-substantive, typographical type of errors, having the CBE and the board authorize us, staff, to make those changes prior to submission to the court.
Okay, then I won't dwell on those at all. So can we have the slide back up? So the question on our earlier slide about whether the CBE and the board, it was requiring us to have a great degree of expertise in exam development.
Slide 5, Devin.
By that, I could see, let me first say that I think the different levels of expertise could be appropriate for the CBE and the board. The CBE is primarily responsible for developing the test. So I don't think it's unnecessary for us to have expertise. That's our job. If we didn't do so well just delegating out to others in the preparation of February, and but I can see the board not needing to have as much expertise because they're not as directly involved as we are. So what are you getting at with that?
Certainly, apologize for the lack of clarity there. This was not to suggest that neither CBE nor the board needed expertise. The issue is here was by having all of these items that the CBE is responsible for and the board exercises oversight. Are we duplicating effort by having both the CBE and the board have to develop expertise in those areas? So grading being one of those examples, where staff were recommending eliminating the board role in that, because that didn't feel like something that the board needed expertise on. One of the at the July 3rd meeting, one of the trustees who isn't here today, but did raise the question, well, if we, the board, are going to take these new responsibilities on, could we hire a consultant in order to advise us so that we can make the best decisions possible? And again, this sort of goes to the issue of, is that necessary in light of CBE having sort of primary authority and expertise designed to have expertise in these areas? And so that's what that question was designed to get at.
Okay, and yeah, I recall watching the meeting and seeing that, and I was a bit taken aback. We use a consultant in the development of our exams. We have a psychometric consultant, so I would think it would be overkill and unnecessarily expensive for us to have a second consultant second guessing the first one. And then as far as eliminating the TA standards reference, is the impact of that the board would not need to approve those? Because we may find ourselves needing to set standards. I think you were making an argument that we want the process of changing our standards not to be so time consuming and lengthy that it reduces our flexibility. Is that what you're trying to get at?
So largely what I was trying to get at, and this is sort of goes to the distinction between rules and standards. And while we were and I'm sure, Mr. Kramer, you will recall specifically because of your fabulous memory, while we were developing the changes to the testing accommodation rules, we had originally put I'd say very little meat into the rules themselves. We had developed a framework, and we were calling it a framework, or we were calling it standards for how we would apply testing accommodations, right? And the framework was where we had where staff was recommending that, and the committee and the board also, as we put these out for public comment, but was recommending that we use for testing accommodations, we rely on testing accommodations that had been awarded to that applicant in certain other high stakes exams. If those had been, if they had received testing accommodations in other high stakes exams, they should, and they have the same functional limitations, they should receive them on this exam. Those kinds of things that we put in that framework of those standards, the public raised significant concern about, because they wanted to make sure that there was process in order for those to be changed. There was, in this area, I think there is a significant amount of distrust of state bar staff, to be honest. And so they wanted to make sure that there was process, and they wanted this in rules, not in a framework, not in standards. And so that was what I was reacting to in proposing to eliminate the provision that the Supreme Court had put in that says that in carrying out their responsibilities, the committee must develop and maintain standards regarding bar examination testing accommodations, subject to review by the Board of Trustees. So that was what was intended by my proposal to eliminate that.
So to eliminate the requirement that the Board of Trustees review, because I would argue our framework is basically the equivalent of standards. You're just talking about not having an extra layer of review of it. The committee would still have to adopt it during a public hearing or public process, correct?
So right now, that framework doesn't exist. It was rolled into the rules because that was what the public had wanted. So my suggestion was actually striking the language entirely. What I hear you suggesting is putting the language back in, but taking out the phrase that says subject to review and approval of the Board of Trustees. So just so everybody's following along, that's Rule 9.6A4. The staff recommendation had been to strike that language. What I hear Mr. Kramer recommending is keeping the language, but just taking out the reference to the subject to review and approval by the board.
Oh, no, actually, I'm happy with taking that out. I was just trying to understand what the effect was, and you've clarified that for me, so thank you.
Apologies.
Donna, one point of clarification. Are you asking for input as to whether we need to further consider when the cost-benefit analysis would be triggered? Are you asking for inputs?
Yes. So on that, the recommendation is that the cost benefit analysis would be required if there are any changes with regard to A1 or A3, which is utilizing the services of third parties to prepare bar exam questions. Right. So if there's a change in vendor or developing and maintaining a rubric for assessing the ability of a third party vendor to administer a proctored exam, those are the scenarios in which staff is recommending that the cost benefit analysis be limited to those areas.
So in my view, the amended rule 9.6, obviously it could theoretically be further elaborated to define what constitutes a change that would trigger the cost benefit analysis. Personally, I don't believe it is necessary or advisable. That's because much of the applicability of this requirement will be largely informed by our common sense and sound judgment exercised by the board and the CBE in collaboration with the staff, obviously. I think attempting to codify sort of an exhaustive list of qualifying changes would risk being either over-inclusive or under-inclusive in some form. Instead, I think we should treat this as more of a functional principle-based standard. For example, a change that would affect how applicants prepare or study, or introduce a new delivery platform vendor, as you mentioned, or question formats, as well as things like the frequency, the length, the scoring of the exam. Those would obviously fall within the scope of this amendment and would then warrant a cost-benefit analysis. Conversely, pure internal process improvements or clerical-based corrections obviously would not trigger this requirement. And then I want to make this very clear because I want to make sure that we preserve both the flexibility and also responsibility, right? We want to make sure we respect the court's trust in our judgment of the CBE as stewards of the licensing process without creating unnecessary procedural hurdles. In short, really, what I'm really saying is I think we should always err on the side of caution by conducting a cost-benefit analysis for any significant change. I just don't believe it is necessary to ask the court to spell out every specific trigger because, again, I don't want to risk substituting something so rigid where we could, merely exercise caution in deciding what is appropriate in the circumstance. So that's just my personal view, and I will, pass the baton back to you.
So,
I have a
apologies.
point that's related, and so maybe you can address both. I'm wondering how this cost benefit analysis would differ in practice from the fiscal impact section that we already have on the staff reports, and maybe that is partially kind of in joint with Alex's comment about where this applies and where it doesn't, since we already have the fiscal impact.
Thank you. I'll answer both of those. So, so the current language of the court's proposal, and this goes to Alex's question, says, in proposing any changes to the administration of the bar exam under 9.6A, right? So that is third-party vendor to prepare questions, maintaining qualifications for content validation panelists, maintaining standards for third-party vendor to administer, maintaining the grading process, right? So in proposing any changes under A, the Committee of Bar Examiners must include a cost-benefit analysis. So I was trying to limit that, and it sounds like, Alex, what you were suggesting was that there should be flexibility in the committee should be able to determine when it's appropriate to do that, sort of using common sense, and when it's appropriate. So it sounds like what you would be recommending in light of the current language that's proposed by the court is even greater flexibility. So potentially in proposing changes to the administration of the exam, the Committee of Bar Examiners must include a cost-benefit analysis, where appropriate, or something like that. That seems to be what you're suggesting. With regard,
I don't want to limit. I mean, the language itself is pretty clear. Any changes to the, and I will quote, administration of the exam described in subdivision A. And so this language is pretty broad. And again, administration could cover foreseeably a number of things. You will have major and minor ticket items, and I again, common sense would dictate when and what would be necessary. I just don't want us to be overly too rigid in trying to limit the meaning of this language. I mean, I think the court would also appreciate us exercising judgment where necessary, so that it is not burdened by even the most mundane questions, if that makes sense.
it does. I don't think the language as currently drafted would allow the committee to exercise its common sense in that way that you suggest. I think it would require the committee to do the cost benefit analysis. You may read that differently. That's the way that we've been reading it.
Yeah, I see it Donna's way.
With regard to Ashley's question, the cost benefit analysis and the elements of that cost benefit analysis are set forth in the rule, and it would be considerably more detailed than the fiscal impact and personnel and the fiscal and resource impact statement that we currently include in the staff reports. That's not to say that what we include in the staff reports couldn't be more robust in certain circumstances, but this is requiring something that's considerably more robust. The direct and indirect costs and the tangible and intangible benefits of the existing practices compared to the proposed changes. Any other alternative existing products or services that are feasible to accomplish the same goals and objectives that might cost the same or less, whether the new technological requirements or new fees that are needed to implement any of those changes would place an undue financial burden on the examinee, the estimated number of full-time equivalent staff necessary to implement the proposed changes, time frame to competently implement, and whether the proposed changes have previously demonstrated their efficacy under similar types of testing conditions. So a lot more specificity.
Hi, Donna. This is Jillian Smith from Committee of Bar Examiners. I had two questions for you. For 9.6B, is the staff recommending removing the language about the substantial modification? Because that seems like that would limit that any changes for which this cost and benefit analysis has to be done would be limited to substantial modifications, not just a broader any changes. And then number two, for 9.6A6 about the must consulting with law school stakeholders, I was just wondering if you could give a little bit more information about what that would look like.
Certainly. So 9.6 B, the first sentence, I believe, is what you're pointing to. So 9.6B, that lead-in sort of has two components. The first one, which I'm striking but moving elsewhere, any changes to the bar exam that require substantial modification to the training or preparation must be approved by the Supreme Court. So that's one thought. And because it's unrelated to the cost benefit analysis, I'm just proposing moving that to the new C. And then with and because the second element of that paragraph then is right. So those things that require substantial modification need to be approved by the court. Any changes to the administration under 9.6A have to have a cost benefit analysis. So there were just two seemingly different thoughts in that paragraph. And so that's more of a technical suggestion there. With regard to the consultation with law school stakeholders, the proposed language is, and the lead in here is, in carrying out its responsibilities for administering the bar exam, the committee must consult with law school stakeholders on issues relating to the subjects that should be tested on the bar exam, the experience of examinees, and effective design and delivery of exams to ensure such perspectives are considered. This is lifted heavily from public comment, not verbatim, but heavily from public comment from law school representatives.
I guess going back to the B, I guess the way I was reading it was that the any changes in sentence 2 relates to sentence 1. So I'm not sure if that we could reword it that way to, to say for clarification, we're taking the any changes to mean only ones that are substantially modifying and not any changes that, I don't know if that is something that, others would be interested in as far as a limitation, I guess, as to what changes need this, larger cost and benefit analysis.
I think that's a totally appropriate question for discussion amongst the group. Certainly an amendment that we could effectuate language-wise, if that is the will of the committee and the board.
So what would the language look like if we were to incorporate this, the substance of this proposal?
So it would say, so we would essentially restore the first sentence in B. Any changes to the bar exam that require substantial modification to the training or preparation required for passage of the exam must be approved by the Supreme Court. And then the next sentence would be changed to say, in proposing such changes, the Committee of Bar Examiners must develop a cost-benefit analysis to assess.
I do like this proposal a lot more. I think substantial modification, on the one hand, would address my issue, but also, ensuring that we're not sending even the most minor modification to the court, and also add in the cost benefit analysis, which obviously would be burdensome at times, and it takes a lot of time to prepare when I understand it. So I think I'm okay with that proposal. Any input or comment from the board or members of the CBE about this proposed change?
Can you read the first sentence again, Donna?
So the first sentence would just be restoring the first sentence that already exists in B. Any changes to the bar examination that require substantial modification to the training or preparation required for passage of the examination must be approved by the Supreme Court.
Okay, so then those would be the only changes that are subject to the cost benefit analysis then?
That is the proposal, yes.
Yeah, that does narrow things. I like that.
This is on page 64. This is on page 64 for those who are looking at the packets.
I see a hand.
Yeah, I would just voice my support of this modification. And I think one of the things I was struck with when looking at the materials was this desire. I think in the wake of controversy, there's sometimes a desire to heap on layers of bureaucracy, but that's not necessarily the best thing in all scenarios. And so I would hate to go back to an environment where the board is referred to as a distracted regulator. I think that we put great trust in the Committee of Bar Examiners, and a lot of the members of CBE are really chosen for these specific types of tasks. So I'm in support of the comments.
Thank you, Chair Stallings.
Donna, on the consultation with law schools, it had words to the effect we're consulting on the subjects to be tested on the bar exam. In some ways, if for those who believe that the Supreme Court has told us what to do and we're not to change that, I'm not one of them, but that ship has certainly sailed because the Supreme Court's order listed the topics that were going to be on the new bar exam. Is that going to sort of put us in a weird place to say it here again?
So my intention was that when that's an issue, it would be something that would be discussed with the law schools. But as you say, if it's not an issue because the Supreme Court has spoken, right, we are in this interesting period now. We'll be talking about that much more on the next item. But if it's a dead issue because the Supreme Court has already decided it and is not the subject of further conversation, then I wasn't sort of intending to reopen issues that have been decided. But we don't know where we're going to be next week, next year, when we're developing, where are we going to be in the future? And just that was trying to capture sort of the sort of gamut of things that we'd want to capture in rule that we would be consulting with the law schools about.
Okay, thanks.
Donna, in the interest of time, would you like to continue? I think we
Yes.
have covered this. Okay.
Yes.
Okay, just real quick, I know Trustee Tony had his hand up. I want to make sure that he.
Oh, I'm sorry. Thank you.
I no longer have any comments. I'm very pleased with the direction of the conversation. Thank you.
Thank you, Trustee Tony.
Sorry, I have one question.
Please, Dr. Bolton.
How will you determine substantial modification? I think that could be an issue. It's not objective enough.
So that is the reason I think that language is in the rule is because it is verbatim language from the statute and has been in the statute for some time. And that is the language that frankly is being modified right now in the proposal in Senate Bill 253 to sort of further define what substantial modification is in terms of, and we'll be talking about this a little bit more in the next item, but changes, basically it's adding changes to the vendor of the multiple choice questions is considered a substantial modification. So I think I'm not sure that adding further clarity or further precision to that language is necessary at this time. And so that's why staff was not recommending a change right now.
And this language again appears in the California Business and Professions Code, section 6046.6, subsection A, which says the examining committee shall not alter the bar examination in a manner that requires the substantial modification of the training or preparation required for passage of the examination. And so the language is consistent with the statute. So I'm just echoing what Ms. Hertzquist is saying. A good question, Dr. Bolton. Thank you.
Devin, if you could take us back to slide 7. That's where we left off. So grouped under the administrative and fiscal authority, the proposed rules require the CBE to regularly review the revenue and expenses for the admissions fund and to propose a budget for the Office of Admissions. Give CBE the authority to set fees for certain admissions programs, subject to review and approval by the Board of Trustees. And also, not mentioned on this slide, but discussed in a little bit more detail in the staff report, restores to CBE the authority to administer oaths or compel attendance or production of documents by subpoena. Next slide. The staff recommendation here is to clarify that CBE's authority over the budget is subject to review and approval by the Board of Trustees. This is in response to some public comment that suggested that there wasn't clarity on this, though some public commenters were suggesting that in fact, the CBE's authority should be the primary authority, and the board should only have the ability in extraordinary circumstances to overrule the CBE's decisions on what the budget should be. The staff also recommend expanding the list of fees that are set by CBE, subject to the approval of the Board of Trustees. There were some limits that were the types of fees that the committee would have the authority to set were set forth in the rule, but didn't include the first-year law students examination, registration with the state bar, or applications for the practical training of law students program or law office study program. And so staff were recommending expanding it to include those.
Are we better off with the general description rather than trying to list them all? Because we may add some later.
Yeah, I mean, that's certainly a way to go, is to just to take out, instead of adding more, take out the specificity that the Supreme Court had proposed and change it to say set fees subject to review and approval by the Board of Trustees related to admissions programs.
Yeah, I'd hate to have to go back and amend this rule when we add a new program. One less petition for Jean to write. The subpoena authority. Why don't we give that to the whole bar? I mean, the Board of Trustees may occasionally want to investigate something.
So what we are staff is not recommending any changes to the language. What we are recommending is having the Supreme Court sort of making sure the Supreme Court is carefully assessing the authority to add that in. And the reason that we're doing that is that authority previously existed in statute. It was amended out of statute in, I believe, 2018, effective 2019, if memory serves. And so there was a question in our minds of, and I'm sorry, Paul, to respond to your question, that language was broad. The language that was in statute applied to the board and any committee, also the State Bar Court and the Office of Chief Trial Counsel. The statute was amended to just refer to the State Bar Court and the Office of Chief Trial Counsel in particular ways, and took out that authority with regard to the board and any other committee. And so we are just suggesting that the Supreme Court make sure that they're evaluating whether they can, by rule, reestablish an authority that had been in statute but was deleted. Staff were not recommending adding back in any of that same authority for the board or other committees at this time.
All right, they'll have to come to us then.
Any other questions on this grouping of administrative and fiscal authority?
Yeah, just a brief, I don't know if I should say brief whenever I talk, but I had prepared a bunch of comments that I'd hoped would be distributed before the meeting so that I would have to speak for less time during the meeting. Some potential Bagley-Keene issues were raised, and so they never got distributed. But in them, I talked about what's been a crusade for me since, well, before COVID, for sure. When I first joined I was appointed to the CBE in 2016. We used to receive periodic reports and we could make comments on the budget. And over time, that sort of disappeared. And so I've been agitating ever since that we, on the theory that we, in our oversight role, in our policymaking role that was stressed in Appendix I, we need to have the information in order to to set priorities for the staff, the admissions function, to perhaps comment to the board, about needs we see that are being unmet. I've never said that we don't need the authority that one commenter said to set the budget and allow the board to change it only in extraordinary circumstances. We just want a voice, and we want the information to be regularly flowing to us. Which this proposal from the Supreme Court is a very positive step. I see in a later item that the staff seems to be recognizing and accepting that that new approach, or that renewed approach, I'll call it, to informing the CBE about budgetary matters and fiscal matters. But we're still, it's a work in progress because, for example, I only recently found out that the admissions fund is more solvent now because it was merged with the legal specialization fund, which had a very big surplus. I didn't find out because it was the CBE as a whole was informed. I found out because I was looking at an item on the Board of Trustees agenda about adjusting legal specialization fees. And in there, it was noted that the two got merged. And so the admissions fund got an extra $8 million. And that's why we're only going to be insolvent in a year or two, as opposed to being insolvent the start of this year. So again, all we want is the information and a voice. At least speaking for myself, I'm not trying to be the dictator of the budget. But I'm happy to see that we're moving in this direction, and I hope it continues.
Trustee Barahona?
Thank you. Yeah, I echo those sentiments. And I guess, Donna, the question that I have is, I know one of the things that would be a challenge is that staff capacity, right? Staff reporting the Office of Admissions budget to CBE and sort of engaging them, as I think makes a ton of sense, but also then having like sort of duplicate efforts with the board and sort of preparing those reports. And I'm just curious what changed in sort of the thinking here.
Donna, I can take this, if that's helpful.
I got it. I just was muted. Nothing actually changed. The discussion that happened at the July 3rd meeting was that was figuring out what would be the best way to engage CBE on this. The concern that was specifically raised by Leah was that if the committee bar examiners wanted to create a finance subcommittee, having to staff a finance subcommittee, report to the finance subcommittee, report to full CBE, report to the board's finance committee, report to the full board, that would be problematic. And that would not be something that we would be able to do. And so the idea was just to make sure that we have shared expectations about how this would happen, how we would be able to present the budget in a meaningful way to the Committee of Bar Examiners, have them give meaningful input that we have the opportunity to react to before then moving the budget to the board's finance committee and ultimately the full board. So I don't think it really is a change of position. It's just sort of getting an understanding that we do have to have a reasonable process in light of that extra work for really finance staff more than anybody.
Got it. Thank you so much.
This is Erica. I'll just briefly add. So we have been talking about this with Araceli Montoya Chico, our CFO, and trying to figure out the cadence for this is really the challenge. So as you all are aware, the budget is due end of February to our external stakeholders. And so working backwards, making sure that we have the right numbers to share out to CBE, then to Finance Committee, and the time to make any changes based on CBE's input, get it to Finance, which usually meets in January, allow for them to make changes, and then get it to the full board in time to get those out. And so that's what we're trying to work through, is how to accomplish all of those things and give the Office of Finance enough time to do that and give you real numbers.
I remain encouraged.
I think in my personal view, and I'm just looking through some of the materials the staff has put together. I understand some trustees have some questions about the value of having the CBE develop recommendations on the budget. And so just let me begin by acknowledging and reaffirming the board's overarching fiscal authority. That authority is foundational to what we do, to the state parks resources, and nothing about this provision is meant to undercut that. And I'm sure the whole CBE would agree with me. We fully respect the board's role and responsibilities in this domain. Instead, what this provision would allow us to do is really for us to provide informed or collaborative input from our unique vantage point, one that is really rooted in the operational and policy details of admissions. Now, our goal is not really to duplicate effort or insert unnecessary steps in the budget process. Instead, it is really to provide practical and really targeted recommendations that truly reflect the realities of administering the bar exam, overseeing more character determinations, and also just ensuring an equitable admissions process after all. We understand, obviously, our trust has to be earned, and we hope that through this new role, the board will come to see our input not really as a complication, but really as a value add, one that really leads to more thoughtful planning and just greater financial responsibility and stability in the admissions fund, and also strong alignment between policy decisions and the budget. With that, our shared goal is really one of financial, and really we just want to make sure that the CBE is able to contribute meaningfully toward that goal, having a resilient budget system while continuing to defer to the board's final authority on the budget adoption. So with that, hopefully that helps some of the trustees answer some of the lingering questions, and hope that we will continue to be able to provide meaningful input on the budget going forward.
There are no more questions on this grouping. If we can move to the next slide. There we go. Thank you. Under the governance, delegation, and appointment procedures, grouping of rule changes, the Supreme Court's proposed revisions relate to Supreme Court appointments to the Committee of Bar Examiners and qualifications for those appointments. They relate to a new Committee of Bar Examiners' responsibility to recommend candidates for the Director of Admissions, and also to delegate certain responsibilities of the CBE, giving them the authority to delegate those responsibilities to a subcommittee. If we could go to the next slide. And then let's jump up actually to the next slide after this. So staff recommend a minor change related to the CBE's recommendation of the Director of Admission to clarify that the recommendation relates not to the Director of Admissions role, but rather to the Chief of Admissions or similar chief level role that has responsibility over admissions. And also to be clear that the recommendation is to the Executive Director and not the board, as the board is not currently involved in the selection of the admissions chief or the admissions director for that matter. With regard to the issue of delegation to a subcommittee, staff are recommending adding language that makes clear that actions taken by the subcommittee be reported to the full CBE at the next meeting, but staff are not recommending, as some public comment did, that any action taken by the subcommittee be subject to ratification by the full committee at its next regularly scheduled meeting, as that would severely impact the efficiency that is gained by allowing the delegation in the first place. And then finally, in response to the comment from a Committee of Bar Examiners member, staff are recommending that the Supreme Court appointees be allowed to hold over after the end of their terms, consistent with the way other appointees by other appointing authorities for the CBE are allowed to hold over after the end of their term. And I will stop here before moving on to the final grouping of rules to see if there are any questions or comments with regard to those recommendations.
Comments, questions from the Board of Trustees or members of CBE?
So you're
Seeing-
done then, Donna? Or is there more?
There should be one more grouping.
I'm sorry, so this is the last slide on this grouping, and then we are moving to other admissions related rules.
Yeah, okay, on the delegation to subcommittees, to allow even more flexibility, we could say that when the delegation is made, the committee will specify whether the decisions take effect when they're made at the subcommittee or they have to be ratified. There might be some cases where we want to do that. But I agree that if we send something off to a subcommittee and we have to ratify it, then we haven't saved any time, and that's almost always why we create smaller groups, is to save time. A good example is testing accommodations. We try to get those decisions out. The appeals so often are coming right before the bar exam they want the accommodations for. And so we want to get them the decision as soon as we can, not wait for the next CBE meeting.
Thank you, Mr. Kramer. See no hands, Mr. Etzkowitz, you may continue.
Let me just clarify if there is, because I'm sort of taking notes of the things that sounds like we're changing. If there is there a sort of agreement that we should specify that we should change the staff recommendation slightly to indicate that upon the delegation to a subcommittee, the committee shall indicate if the delegation is subject to subsequent ratification.
Yeah, or another way to put it would be, unless otherwise stated in the delegation, the decision of the committee, subcommittee is the decision of the committee without further action. Something like that. You could. So there's clarity. So somebody's not coming back and, we're not litigating something we forgot we could have easily clarified today. Gonna put you out of a job, Gene.
If there's agreement on that, we can capture that in the resolution as well. Moving on then, the next slide. This is a suggestion by Mr. Kramer. When he looked at the rules, thought that there was a real opportunity to make an amendment to Rule 9.30, which is amended by the court. Just the court's amendments are just technical. But 9.30 specifically sets out specific requirements for libraries at unaccredited schools. At a minimum, the school needs to maintain the following books at the library, and the recommendation that Mr. Kramer made that staff is recommending is specifying taking out the specificity of the types of materials that need to be maintained, and instead giving CBE the authority to determine the breadth of materials that must be made available by the schools. And the existing list is it may be both too narrow and too broad. If it is an online school, do they need to maintain a physical library with all these physical materials? Let the CBE make that determination with regard. Otherwise, the list really deals with California specific materials only, and maybe there are some other materials that should be at a minimum required for these libraries. So that's the recommendation, staff recommendation on Rule 9.30.
Yeah, that level of detail doesn't need to be in a court rule.
If there are no questions, then we can move on to the final slide. And that is with regard to the rule revisions in this package that deal with attorney regulation and discipline. There is one change that is noted in attachment D, the red line, and that's just a change to title in Rule 9.13. Staff have noted that public comment on these pieces of the rules were minimal, and our recommendation is that we delegate to the interim executive director in consultation with the board chair and vice chair to identify recommended changes to these particular rules in Title IX, and to convey any such changes to the court as part of the same petition where we're conveying the admissions related rules changes, recommendations for rules changes.
And this is Brandon Stallings. I've been in regular contact with Erica and with Jose on this issue. So I know both Jose and I are happy to continue these conversations with Erica and with staff if everybody else is okay with that.
So this is Paul. I've got two more that were in my undistributed comments. So should I go to those now, Donna?
Certainly.
Okay, so Rule 9.6A1 initially suggested that the CBE attorney members would have to review all the multiple choice questions. Did you revise that to eliminate that? Given that we also have a system where much more specialist validation teams are looking at all the questions, I don't think we need to review those, and that would be quite a burden on the attorneys, given the number of questions, multiple choice questions that are in each exam. So did you fix that?
The language that was proposed by the Supreme Court actually said the attorney and judicial officer members of the committee or their designated content validation panels. So I think it already allowed for what you're proposing, that the content validation panels be the one to review all those questions.
Okay. Last one, 9.6A5. It talks about any changes to the quote passing score need to be sent up and approved by the Supreme Court. I wonder if that could cause some confusion. As we learned when we were going over the mitigation for the February situation, there are raw scores composed of the number of multiple choice questions that were correct and also the points that were awarded for the essays and performance test. And then those, every time we have a test, they are scaled by our psychometrician against the 1390 passing score that was set by the Supreme Court some time ago. So I'm wondering, would it be better to call that the scaled passing score to make sure that nobody can argue that we every time we scale an exam, which is every time we give an exam, it has to be approved by the court? That would just totally blow up the efforts we've made to try to get the results out sooner.
So I think that might be slightly too limiting, because if we are in a situation where we need to, once again, as the committee did for the February exam, set the raw minimum passing score, which needed approval by the Supreme Court. And we will, if we are developing our own exam, we will have to do that again. So I worry just saying the scaled score is too narrow. I don't know if other board members or committee members interpreted the rule language the way you did, sort of requiring the submission of the scaling formula, which is basically what you're talking about, how we convert from the raw score to the scaled score. I personally didn't interpret it that way, but it's entirely possible that others did as well, in which case we just need to figure out what some appropriate language change would be there.
Well, if nobody else has a concern. I just, it seemed to me it could be a point, it could be a speed bump in the road that I'd rather not hit at speed. Jean, do you have any concern?
It's repeating language that already existed, but if it would help, we could change it to must recommend any change to the passing score. Because it's currently set by court order. So this would be forward-looking in the
Okay.
event we needed to change it in the future, that any recommendation would need to be made
Yeah.
and approved by the court.
So it's a different animal than what happens when an individual's numbers are scaled up to the 1390 scale.
Right.
Okay, that makes sense to me. Does that work for you, Donna?
Yep.
All right, thank you.
I think, so that's it for the presentation. And so, you can move to the resolution, which I am currently amending right this second.
Take your time. This is on page 29 of agenda item 2.2 for those who would like to see the resolutions.
Chairs, chair of the board and chair of the CBE committee, if I could make a suggestion, can we take maybe a 2 to 3 or 5 minute break? That way we could implement some of the proposed changes to attachment D and present them to you concurrently with the resolutions for consideration. And that may give you an opportunity for a bio break or anything else that may be appropriate.
Or one of the other option is just changing the resolution to reference the changes to 9.5A, 9.5B4, 9.6A, and 9.6B discussed in the August 14 meeting. If we could just do that, then we don't need to change the attachment right now.
I second the break.
Yeah, I wouldn't mind one.
All right. I want to make sure that staff also gets a break too. So does a 5 minute bio break allow for that, or do we need a little bit longer?
That's fine, so long as someone sends me attachment D.
All right, let's take a 5 minute bio break. And if we need a little bit more time, we'll do that. So we'll see you guys in 5 minutes. Looks like a majority of us are back. However, I do want to give staff time for their break, as well as to make sure that the language is reflected in the resolution. So we should get going shortly here.
Yeah, which is true also.
How are you gonna get to Sacramento?
I'm driving. I drive from.
Chair Stallings, I think we're waiting for a few more edits, and I also think we're waiting on a quorum.
Okay.
I have Dr. Bolden just outside whenever we need him. Audrey, I have Dr. Bolden right outside here whenever we need him.
And I have the document ready.
Thank you.
Perfect. It'll look like we have quorum.
We do have a quorum, Chair.
All right. If you're ready to begin recording, let's go back.
Chair Stallings, I do want to note for the record, Trustee Gore joined the San Francisco office and Trustee Stevens joined remotely around 10.
Perfect. Welcome to you both.
And we are live and recording.
Great. Welcome back, everybody. We're back from our bio break. We are concluding item 2.2 just to give everybody a little bit of a roadmap. We are going to move next to 2.3. Kind of the literal carrot at the end of the stick is that we will take then a brief break to gather some lunch, and then I anticipate we'll work through lunch on the remainder of these items. So with that, Chair Chan, I will turn it back over to you.
Thank you, Chair Stallings. Ms. Hetzkowitz, I believe you have the amended resolutions. If so, can you put it up?
Yeah, so we've got the resolution, but also let's first go through the amended attachment D. Since the decision was to put the language in the attachment itself and not in the resolution. So I can share my screen. And let me scroll here to the language. So first we have the changes, and because of it was hard to distinguish what was new from what was old. And so I've just highlighted any changes here in yellow. And so this is eliminating the delineation of the fees that would be subject, that the CBE would be responsible to set, subject to the review and approval by the board, to just change it to say set fees related to admissions programs, and then taking out the delineation. So that was the first change. Next, and that was Mr. Kramer's suggestion. With regard to the delegation of duties, I have added, unless otherwise stated in the delegation, the action of the subcommittee shall be the decision of the committee without further ratification. And added that before the sentence that did require the actions of the subcommittee to be reported to the full committee at the next regularly scheduled meeting. Then next.
Question back on that. Do we want to make that a requirement? I guess it could be on consent, but is that extra work we don't need in some cases?
Are you talking about the report back?
Yeah.
Yeah, I think there should be a report back, especially if the subcommittee is taking a final action on something.
Testing accommodation appeals then too?
That's not included in this. This is specific to some of the new requirements in this rule.
Okay, thanks.
Then scrolling down here to Rule 9.6. The committee must recommend any change to the passing score, not just the passing score pursuant to Mr. Kramer's question. Any change to the passing score for the bar examination subject to review and approval by the Supreme Court. And then Ms. Smith's recommendation, restoring the language that existed before this first sentence, any changes to the bar exam that require substantial modification to the training or preparation required for passage of the examination must be approved by the Supreme Court. And then altering the next section to read, in proposing such changes, the committee of bar examiners must develop a cost-benefit analysis to assess if relevant, et cetera, et cetera. As a result of restoring that first sentence in B, I am now deleting C, where I had moved that first sentence to. And what we will do as part of the resolution, which allows staff to make technical changes, I will re-letter the subsequent paragraphs in this rule. So D will become C, and then the last one will return to D. And so that's it for the changes that we discussed. Any other changes that I left out? Okay, I'm going to stop sharing. And with that, then, Devin or Sharon, if you can share the resolution. And the resolutions you will see do also include the language that I had mentioned before, giving staff the direction to make any technical and non-substantive amendments that are needed.
Donna, this is Alan in LA. I'm sorry, I just now noticed there's a reference there to on the fingerprinting. The notification of subsequent arrests is stricken out.
Oh, in 9.9.5?
Yes, should have caught that before.
So it's that is a clarification. It's a clarification. There is already statutory authority that we get notification of subsequent arrests. This, as I recall, this was a timing issue. Some of the language of the rule that was stricken had to do with the process of getting everybody to get re-fingerprinted. And so there's no change to the fact that we will continue to get background information and subsequent arrest notification.
Got it. Thank you.
I'll make the motion, Paul Kramer.
Alan Yokelson.
Thank you, Mr.
will
Kramer.
Second. Alan Yokelson will second.
Moved by Mr. Kramer, second by Mr. Yokelson. Any further discussion or input from CBE members? Seeing none, Ms. McFarland, please take roll.
Bolton,
Yes.
Cow, not present. Gongora,
Yes.
Kaplan, not present. Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla,
Yes.
Montgomery,
Yes.
Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna, not present. Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you. This motion is passed. I will now pass it back to Chair Stallings.
All right, so this is now the board voting on, the board of trustees voting on the resolution. I will make a motion to adopt the resolution. Can I have a second?
Second.
All right, that was second by trustee Harrison.
Yes.
Perfect. Ms. Lim, can I take a roll call vote, please? Or can you
Vera-
take a roll call vote, please?
Yes. Barahona,
Aye.
Buenaventura,
Aye.
Cisneros,
Aye.
Good, not present. Gore,
Aye.
Grande,
Aye.
Harrison,
Aye.
Huser, not present. Sowell,
Aye.
Stevens,
Aye.
Tony,
Aye.
Trejo,
Aye.
and Stallings.
Aye.
With 11 ayes and 0 nays, the motion carries.
All right. Thank you to staff, to both Committee of Bar Examiners and Board of Trustees on just working through a very complicated set of issues. Really hoping that the comments that we received through the public comment period, that we're really able to capture the spirit of those, the spirit of both of these bodies, and transmit these to the Supreme Court for appropriate action. We're going to take up item 2.3. And again, as I mentioned before, the literal carrot is that we will take a brief break for lunch so we can continue to work through this agenda. But item 2.3 is a discussion and action, if appropriate, on the development of recommendation for future California bar exam following the July 2025 administration. And we're going to turn it back over to Chief of Admissions, Don Hershkowitz.
Good morning again. I thought the last one was going to be easy, so this was going to be the meaty one. I'm sorry, Devin, if you could put up the slide deck. So I'm going to start with a little background to set the stage for the committee members and the board members, and then turn to what I hope is a in-depth discussion from all of you on the considerations and your thoughts about future administrations of the bar exam and the principles and priorities that will ultimately help you develop your recommendations to the Supreme Court on what the future bar exam should look like. I'm not going to repeat all of the background in the staff report, but I am going to highlight some of the key points. Next slide. And I will also point out, if you are following along with the materials, shortly before the meeting, I reordered some of the slides and made one key change, which I will go into some depth on when we get there. But the goal of today's presentation is to make sure we have an understanding of the timeline for the decision making, because it is sooner than it feels like when we talk about ultimately when the next when the next new exam might need to be administered. I want to obtain preliminary feedback from all of you on the options for the future bar exam, and obtain some feedback from you on what information is needed in addition to what we will already be required to collect for the cost benefit analysis, but what other sort of additional information, perhaps non-financial information, would be needed for you all to feel comfortable making your final recommendation to the court. Next slide. So how did we get here, right? Why are we having this conversation today? So in 2021, the Blue Ribbon Commission, which is a joint commission of the Supreme Court and the State Bar, the Blue Ribbon Commission on the Future of the Bar Exam, began meeting and it began what ended up being 2 years of meetings and discussion on whether California should develop its own bar exam, and if so, what should be tested on that exam. Their charge also included to consider whether California should pursue alternatives to a traditional exam. The Blue Ribbon Commission explored advantages and disadvantages of developing our own California-specific exam or adopting the next-gen uniform bar exam. The Blue Ribbon Commission was driven by principles of fairness and equity, including how those issues relate to the mode and the method of how the exam is delivered. And ultimately, after considering all of that and having 2 years of discussions and hearing about what was known at the time about the next gen exam, and talking to psychometricians, getting a lot of background, ultimately the Blue Ribbon Commission recommended, and then the board passed along to the Supreme Court the recommendation that California develop its own exam that would include California law. The Supreme Court agreed with the recommendation, made some modifications, ultimately recommended 12 topic areas that were to be tested and 7 skills and abilities that were to be tested. The goal was to create an exam that relied less on memorization and more on skills and abilities that would be needed by entry-level attorneys. In early August of 2024, the State Bar contracted with Kaplan Exam Services to develop multiple choice questions to make the current exam more accessible and affordable in the short run. This was intended as a bridge to the new bar exam that was directed by the Supreme Court, the new bar exam being estimated as a 5-year development effort. And so by switching from the multi-state bar exam, the multiple choice segment that is produced by the National Conference of Bar Examiners, the idea was to give California some flexibility in how we administer the exam in order to make it more accessible and more affordable in the short term. In February 2025, we administered 2 significant changes to the exam. One was how the exam was administered, being administered remotely and in test centers that were operated by the vendor, and also at the same time administering these new multiple choice questions. So and there were though the most significant feedback the board and the committee has received is with regard to the administration, the remote administration and the in-person administration. There were also significant comments that the committee and the board received about the content of the exam. The staff report goes into detail about how the content of the multiple choice was developed. The different authors of different multiple choice questions, and you all are very familiar with the concerns that were expressed about the perceived problems with the questions and with the content. As a result, the Supreme Court directed that first directed that we return to an in-person administration at state bar run sites, or suggested that we planned for an in-person administration, not a remote administration for the July exam. And then subsequently, the Supreme Court directed that we return to the use of the multi-state bar exam for the July exam. They've made no recommendations as to future, but for July, in person and adoption of the MBE. The adoption of the MBE alone certainly would have necessitated the return to the fully in-person exam at the state bar administered test sites, as that is a limitation that is imposed by the National Conference of Bar Examiners. As I was saying before, one of the reasons that we switched to Kaplan was to provide us opportunities to be more flexible in how we administered the exam. Those opportunities didn't exist with return to the product developed by the National Conference of Bar Examiners. So next, also after the February bar exam, hearing a lot of concerns about the content of the exam, Senator Umberg introduced into Senate Bill 253, which is the annual state bar licensing fee legislation, introduced language, excuse me, that would require 2 years notice to return post the July 2025 exam, to return to Kaplan or any other vendor for the multiple choice questions. Any other vendor that is not the National Conference of Bar Examiners, would require us to have the 2 years of notice in order to return to that, or to switch vendors. Next slide. So with this background, we will soon be proceeding to a discussion of the different options that are laid out in the staff report. But the options take into account the assumptions and considerations that are set forth in this slide. You'll see a couple of things bolded under the considerations. And I do want to point out a change, that is a change in this slide. And will affect the rest of our discussion. And there were a couple of other slides where I made similar changes. And the change is this. We had been operating under the understanding that July 2027 is the last time that the MBE will be offered as a standalone product, meaning that no matter what it is we choose to do, if SB 253 is enacted requiring the 2-year notice of the change in the development vendor, which is one of the assumptions that we're operating under here. If that was enacted, and if the July 2027 was the last time that the MBE would be offered as a standalone product, then the requirement would be that no matter what it is that the board and CBE and the court ultimately decide to do, we needed to be ready to launch something different as of February 2028, right? What we had been using up until then, again, assuming SB 253 is enacted as it's currently worded, using the MBE would not have been an option. So February 2028, we would need something new. So we have just learned that the MBE will in fact still be offered as a standalone product in February 2028. So extending for sort of 6 months the ability to offer the MBE. So if CBE and the board wish to so recommend, the existing exam, and by existing exam, I'm talking about what we administered in July, which was the MBE and SAMPT, California SAMPT questions, the CBE and the board, if they so wish to, could recommend that the existing exam continue through and including February 2028, as opposed to through and including July 2027. Pushing the decisions and the products that we would need to produce by 6 months. I've updated a few, but not all of the slides in the deck to address this information. So quickly, the underlying assumptions here for all of the options and the pros and cons of the options that are laid out in the coming slides. The assumption is that SB 253 is enacted and a 2-year notice will be required to change the vendor for development of the multiple choice questions. That the Title IX revisions that we just finished talking about are enacted, triggering the requirement for us to do the cost benefit analysis. And also that AB 484 is enacted, which requires an evaluation of whether the next gen UBE reduces costs and increases efficiency. That analysis would be included as part of any cost benefit analysis we did. Considerations were that we do have State Bar has an existing 5-year contract with Kaplan to support development of new multiple choice questions. That contract also includes development of essays and performance test questions. We are fully confident that the Kaplan developed multiple choice questions will be ready well before February 2028. And we have created enhanced processes to validate the content of those. And in terms of getting the MCQs ready, that also includes well before February 2028, being able to publish a new faculty guide, a new student guide, and the final content map. Those would be ready to be published as soon as the board, when the board makes a decision on what to go forward with. Again, the consideration is now that February 2028 is the final scheduled administration of the multi-state bar exam. Any significant changes to the bar exam to the bar exam training or preparation that are required for passage must be approved by the Supreme Court. And again, a new exam must be fully ready for implementation by July 2028 at the latest. Next slide. So this timeline was, of course, based on the assumption that the MBE would no longer be available in February 2028. So it assumed, right, if by February 2028, no matter what you chose to recommend, we had to have something other than what we administered in July in order to give that 2-year notice. That 2-year notice would have to be given in February 2026. And then this timeline walks us back from that February 2026 notice in terms of the steps that are required to do this. As I mentioned, now July 2028 would be the exam that absolutely, without question, has to be different. I may be apropos of nothing, but I would also note that during that the administration of the July 2028 bar exam is during the Olympics, which is going to be held in the greater Los Angeles area. Mr. Stallings, that's the exact look that I had when Audrey reminded me of that. I bring this up only to say that the board adopted guiding principles, which we'll be discussing in a few minutes, valued rolling out changes one at a time. And depending on what we would need to do to seat applicants who we would normally expect to test in the LA area, that might be one change already that we need to do for July 2028 as we try and figure out locations to test the exam if we are testing at big in-person sites. And so just in terms of, if we're rolling out a new exam, are we going to roll it out in July 2028? At the same time, we have some challenges about where we might be seating people who would be taking the exam in Southern California. So just a little glitch to put on your radar screen. Next slide. Oh, and I'm sorry. And on this slide, do note, as the footnote points out, that this timeline, which again could be pushed 6 months now, but this timeline is based on the current CBE and board's regularly scheduled meetings. So it has a cost-benefit analysis coming to the CBE in October, their regularly scheduled October meeting, to the board at their regularly scheduled November meeting, so that staff can then turn around the recommendation, the cost-benefit analysis and the recommendation of what the future bar exam should look like to the Supreme Court in December, turn that around to the court and also turn it around to the legislature so that the court has the opportunity to thoughtfully weigh in time for us to give notice if we want to make a change to the exam that's going to be administered in February 2028. Next slide. So before we talk about the different options for a future bar exam that are identified in the staff report, I wanted to remind everyone, as we just talked about in the last item, that in proposing any changes to the format, content, or scope of the bar exam, assuming the rules to Title IX are adopted, we will need to perform a cost-benefit analysis that assesses the direct and indirect costs of the tangible and intangible benefits of existing practices, how we currently administer the exam, as compared to how we are proposing to administer it in the future. The cost benefit analysis would need to look at any alternative products or services that are feasible to accomplish the same goals and objectives as the proposed changes, that are available at a comparable or lower cost, whether there are any technological requirements or new fees that are required to implement the proposed changes that would place an undue financial burden on examinees, the estimated number of full-time equivalents that are necessary to implement the changes, the estimated time frame to competently implement the changes, and whether the proposed changes have previously demonstrated their efficacy under testing conditions similar to a bar exam. Additionally, under AB 484, that cost-benefit analysis would include an analysis of whether the next-gen UBE would be more efficient and lower cost than what it is we are proposing. So the reason I lay this out here is as we move on to talk about the different options for your consideration, I would ask that you think about what information other than what we already need to gather to put into this cost-benefit analysis. What other information would you want to see to help you finalize your recommendation of your recommendation to the court of what the future bar exam should be? Next slide. So this slide identifies summarizes the three options that are identified in the staff report. Option one is really continuing with what the plan was, which is at the conclusion of the two-year notice period, we would return to the Kaplan developed multiple choice questions and continue with the California developed essays and performance test questions as a bridge to the new bar exam development effort that was directed by the Supreme Court upon the recommendation of the Blue Ribbon Commission. Option number two, instead of developing a new exam, we would, upon giving our 2 years notice, the expiration of that notice, we would adopt the next gen UBE, and we could consider adding a half day of California specific content. And the reason I specifically said a half day, the next gen UBE is designed as a 1.5 day exam. There are other states that have announced that at the end of that second day, after the half day, that they will be doing state-specific testing at that time. There would also be an option, frankly, for CBE and the board to recommend and the court to adopt a requirement that we do some California-specific, whether it's a California-specific exam, California-specific training at another time. Certainly, if it's an exam, getting everybody together in a room twice would be complex and expensive. But if there are other options for how we would deliver California-specific content, that could be cost-effective. Option three is instead of adopting next gen, and instead of going back to the plan, which was a bridge to a future development, that at the end of our 2 year notice, we go ahead and we launch the new bar exam. And the new bar exam would be a streamlined version. So it would be a significantly smaller development effort than was anticipated with what was recommended to the court. One of the options that is possible here, and this is just put out as an option, is doing 100 or 120 multiple choice questions and three or four performance tests, or some other streamlined structure that the committee and the board recommend doing. So these are sort of the three options that we've laid out to really get this discussion going. I do want to make sure to note that option one and option three could conceivably look very similar. Option one just giving us extra time to get there, because ultimately there will be advisory committees and steering committees and development experts who will make recommendations about what the new bar exam envisioned under option one would be. They could come up with a streamlined exam that looks like option 3, or could come up with something very different. We certainly talked about initially when the Blue Ribbon Commission was meeting, we talked about simulations and a gamified assessment, and something that I always irreverently referred to as similar to choose your own adventure books, where sort of depending on how you answered something, you would get a different question would come to you. There are certain exams, licensure exams, that work that way. So just wanted to sort of put that out there in case you were, I don't want people to walk away thinking option 3 is always going to be very different than option 1. They could end up looking similar as a possibility. Next slide. So, sorry for this one, I took notes on the slide. So I just want to highlight a few of the pros and cons from each of the options. So again, option 1, keeping things sort of the way we had planned, returned to Kaplan for the multiple choice questions as a bridge to the development of new exam. Some of the pros of this is it's consistent with the direction that was ordered by the Supreme Court in October 2024, and it provides us the greatest flexibility in both exam development and exam delivery. The delivery could be multiple times a year, it could be remote, it could be at small test centers across the state, it could be at large in-person test centers. It just provides us a lot of flexibility. We could offer the multiple choice before somebody graduates from law school, and another part of it after they graduate from law school. It allows for innovative test design and allows with the desire that we have heard from test takers in our post-exam surveys for exams that are conducted remotely or closer to home. On the con side of this, State Bar staff are not professional test developers. We obviously would not be developing the tests ourselves. We would be bringing in vendors who do in fact have this experience, but obviously there is a requirement on staff to oversee that development effort, and we are not professional test developers. The development of the exam may be costly. It may be significant. Prior estimates that were presented to the board said that the cost of the new exam, depending on how we do it, could range anywhere from $2 million to $10 million, depending on what's developed. And the resource requirements, the staff as well as the fiscal, could impact our ability to do other admissions related work. Next slide. Pros and cons for adopting the next gen UBE. Among the pros, 45 other jurisdictions have already adopted the next gen UBE. And that would increase the likelihood of portability of the exam scores. So if somebody scored, scored a certain level taking the exam in California, if we were also administering the next gen UBE, it increases the likelihood that they could take that score to another state and be admitted into that other state without having to sit for another bar exam. The National Conference of Bar Examiners, which has spent several years in the development of this exam and the planning for it and the developing the content maps and printing resources, pre-testing the questions. They do have expertise in exam development and pre-testing and psychometrics that we do not currently have in-house. There would be little to no ongoing exam development costs and resource implications for California, except obviously for if we were developing a California-specific portion of the exam. And in support of or in alignment with one of the adopted guiding principles that the board adopted about better engaging with stakeholders, I wanted to point out that the board and the committee received a letter from 11 deans of ABA accredited law schools supporting and urging moving toward the next gen UBE as the next bar exam. And they identified their reasons for that, noting that the coverage closely aligns with the subject matters ordered by the court, skills and abilities tested closely align with the skills and abilities that were ordered by the court, and we can use the extra half day for testing California specific subjects and skills that are not that the court had previously recommended that are not tested on the next gen. There are, of course, cons. The flexibility that we talked about with option 1 to administer the exam more frequently, to administer the exam in separate pieces, to administer the exam remotely or at small third-party operated test centers like Prometric test centers, Pearson VUE test centers. All that flexibility goes away with the next gen UBE. Also, as you all have heard, doing testing at the in-person state bar operated test sites is the most expensive method for putting on the bar exam. And it is also extremely staff resource intensive, hindering the ability of staff to be responsive to other needs around the time that the bar exam is being administered. Next slide. And for option 3, which was a simpler, more streamlined exam development process that we could launch immediately upon the expiration of the 2 years, having given notice of it, again, it's more streamlined. It would allow us to use the multiple choice questions that we have already contracted with Kaplan. We are paying for Kaplan to develop. Kaplan is also going to be providing essays and multiple choice questions as part of that contract. And so it would allow us to also use the questions that are the performance test questions that are drafted by Kaplan and content validated, to the extent that we select a multiple choice and performance test option. It would be considerably less costly to implement than option 1, and it builds upon what we already have in place. It still allows for the greater flexibility for how we deliver the exam and when we deliver the exam, and it is which would make it more cost effective. On the con side, we would need to, so the court had recommended, court had ordered that the content of the exam cover 12 subject matters. In looking back on that order, it's not clear to me that those all need to be incorporated in the multiple choice questions. They could be, because they don't have to be sort of the doctrinal, the memorization of the doctrinal law. They could be incorporated into the performance test questions, but we would certainly need to talk to the court and make sure to understand how we can make sure all of those 12 subject matters are tested. And we would need to renegotiate any contract with Kaplan, because if the multiple choice questions need to cover more subject matters than they are currently covering, we would need to expand that requirement. And if the performance tests would need to cover more subjects than they're currently covering, we would need to ask them to do that. We could renegotiate with them, because they are also drafting essays, to no longer draft the essays and instead draft more performance test questions. And then finally, the performance test may not be able to test all 7 skills and abilities that were identified in the Supreme Court's direction. So this model of 100 multiple choice and 3 performance tests is a model that the state of Nevada has adopted, and they are in the process of developing in very early stages of development. They just got the approval from their Supreme Court to do this, so they are just starting a development effort. What they included, in addition to the multiple choice and the performance test, was a very small number of hours of supervised practice to get at some of the skills, specifically like client counseling skills, that they felt would be difficult to administer, to test in the exam. However, Nevada has a much smaller number of test takers than California does, and being able to support ensuring that there are supervisors for supervised practice, even for a very short period of time, may not be something that frankly that California can support. So we would need to figure out how to test all the required skills and abilities, in all likelihood, across the performance tests and the multiple choice questions. Next slide. So I just wanted to take a quick second to remind the board and the committee of the guiding principles that the board adopted and the board adopted that CBE also adopt, to help in the decision-making of what the future California bar exam should be. Attachment B in the staff report identifies the extent to which each of those three options aligns with the guiding principles. I don't want to go through that now, and it certainly could not easily fit on the slides, so I am just reminding you of the guiding principles that were adopted. When CBE met on June 20th, CBE started a conversation about the guiding principles, but decided to defer until this meeting a decision on whether to adopt these guiding principles or modify them. And so next slide, just so we can show the other guiding principles. And so we could, at this time, turn to a discussion by CBE members before we switch to a discussion of the different options and questions and refinements and additions and deletions to those options. We could turn to CBE right now and have CBE start discussing the guiding principles and if they have any suggestions for changes to those guiding principles or concur with the guiding principles as written. So I defer to you, Mr. Chair, on if you'd like to do that now or if you'd like to move forward with a discussion of the particular options.
I think this is definitely a very level setting conversation, and I think it'd be important for the board to hear CBE's thoughts. So Chair Chan, if you're okay leading that discussion.
Absolutely. Thank you, Chair Stallings. Let me just start off by saying I love all of these guiding principles. There's one that I would like everyone to consider, which I believe would have some impact on some of these guiding principles, is that we should avoid locking ourselves into long-term agreements that would limit our flexibility in licensing innovation. And I say this because a lot of these guiding principles sort of have this common theme about giving us some flexibility to do a remote online exam. And for that reality to be actually a reality, we want to make sure that we also are not locking ourselves into something long-term such that we would be deprived of that opportunity. I mean, Kaplan would be a prime example. You know, we have a contract with them for 5 years. And as a result, if we were to decide to go with NCBE, obviously that would create some conflict with Kaplan. And so I personally believe one of the guiding principles should also include something along the lines of making sure we avoid long-term contracts. So avoiding long-term vendor contracts while giving ourselves some flexibility in licensing innovation. So that would be one recommendation that I would make. Any comments or input from CBE members?
Well, Alex, I share your concern. I don't think that can be an absolute, though, because if I were a vendor, I'd be reluctant to sign up for a deal that might be canceled the next year. You know, it's a slippery slope, so it should be a consideration, but not an absolute.
Yeah, that's a point well taken. And I certainly expect that vendors, if we have a good and healthy pool of vendors, that could be one thing that could potentially be the tiebreaker, right? If you have a vendor that is a lot more flexible than other vendors, so that certainly could be given some more advantage. But again, you're absolutely correct. This should not be absolute, but it's just a consideration that we need to think about.
And that's
Any
kind
other
of
inputs? Sorry,
that's how I
Mr. Kramer,
feel
go
about
ahead.
these guidelines. They're aspirational, but for instance, I would not want to consider the dark gray one here. Consider both remote and in-person options. I want to consider those. I'm not convinced that we can do remote successfully. Yeah, there's a lot of work to be done. So I really don't want to see it driving this thing. If it can be done, great, but for me, it's not the most important consideration. The most important consideration is, providing a test, a proper test of the skills and knowledge that we believe new attorneys need to possess.
Thank you,
Mr. Chair,
Mr.
this is
Kramer.
Bethany.
Please, Ms. Peak.
Thank you. So first I want to say thank you, Donna, for that really amazing, I won't call it a summary. I think that, minimizes it, but thank you for going through all of that information. One question I was going to ask that you answered was why we were sticking with the February 2028 date. I remember that there was a reason and I couldn't recall the specific one. So thank you for that update. And in light of the fact that we could still purchase the MCBE for another 6 months, then I think that it would probably be preferable if we did extend the timeline, at least the 6 months. I know that one of our principles is, we need to learn from February. And, part of the reason we ended up there is we were backed up against a wall time-wise dealing with the NCBE in the first place. And so I think we should do whatever we can to try to give ourselves as much leeway and as much time so that we can be diligent in developing the next phase or the next iteration of the bar exam. And so to that end, I support option number 3, which I believe was us creating like a streamlined bar exam and having, maybe 100 or so multiple choice questions. From a, logistical standpoint, this is obviously we are one of the largest states. And to the extent that we are going to be developing our own bar, it would be better if we could make it as simple of a process, both for applicants and for staff and for ourselves as we're developing that out. Several years ago, one of our big tasks and discussions was minimum competency. And I know that today still there's a lot of disagreement and dispute about whether the bar exam is actually assessing for minimum competency. But I know there's a lot of support for the idea that the performance tests are more indicative of the actual practice of law than, the multiple choice or the essay questions, because we know that, when we're practicing law, we're not having to remember things off the top of our head. We're having to analyze information and make informed decisions off of that. And so to the extent that we could, develop our own bar, continue to work with Kaplan for the multiple choice questions, and create however many performance tests would be necessary to assess the competency, I think that would be an ideal option. And then quickly, last thing, just going back to our goal of learning from February, I don't think that it's realistic to say that we can't be moving to a remote bar exam. The world, I know the legal profession, it's always slow, it's always behind everything, but the rest of the world is moving. And, we are preparing a bar for the younger generations. And the reality is that people are doing things electronically, they're doing it remote as, economic reasons. I know there were public commenters today talking about they don't want to come to California because the hotels and the food are all expensive. And that's all fair because it's true. And so I think that we need to continue to be proactive about looking to see where specifically technology is developing so that not only as we're developing this bar, but as we're trying to be proactive for, the next pandemic or the next whatever happens, that we are not just like, oh, dang, we only can do an in-person bar exam. So those are my thoughts, Mr. Chair.
Thank you, Ms. Peak. Any other inputs or comments from CBE members?
About the principles, no, but I do have a whole series of questions about the rest of the matters before us.
Okay.
So
well, let me just,
I'm sorry, Mr. Chair, as to the guiding principles, what I heard was adding a guiding principle that makes a consideration not locking the state bar into long-term vendor contracts so as to give us flexibility in licensing innovation.
Correct. And I want to quickly address that one point made by Mr. Kramer as well. These principles were adopted by the board as the framework for how we should approach consequential decisions about the future of the bar. Now, in my view, they do serve a very good compass and really not a checklist to really just make sure our decision reflect fairness, right? Accessibility, reliability, all of those good things that we've thought about. And so while we retain flexibility in applying them, and I agree, it's sort of one thing I want us to keep in mind, we really shouldn't treat them as optional. And really these principles really are meant to anchor our process, our decision-making process, and really to promote transparency, right? And trust in how we evaluate trade-offs, especially when we face competing proposals. And I certainly expect a lot of vendors to be submitting competing proposals. And so we need some guiding compass to make that decision-making, to complete that decision-making. And so again, I think it's important for us to think about this. If we were to treat these principles merely as background noise, we risk making, spontaneous or ad hoc decisions that really lack consistencies. And so these guiding principles, they're not really aspirations in my view. They're more about ways in which for us to make an informed judgment about what makes the most sense going forward. So while I agree in some aspect, what you said, Mr. Kramer, I don't fully agree everything that you said. But anyway, that's just my view. But in that sense, I do prefer some guiding principle on making sure we don't lock ourselves into long-term contract that could potentially backfire on some of the things that we have on this list. Any additional comments or inputs? And Donna, then procedurally, what would you like us to do? Now that we have sort of talked about the guiding principles, would you like to continue on so that I know Mr. Kramer also has other comments for other slides? So procedurally, what is best for you?
Yes, so I would like to turn now to a discussion and refinement of the options. So getting your input on the different options, and then we'll talk about what type of information you would need, right, other than what's already going to be done for the cost benefit analysis in order to ultimately make a recommendation. And I do want to be clear that we're making the recommendation of what the future bar exam is going to be so that we can give notice. So there needs to be specificity in that recommendation. So, right, we can't just say, if we were to select option 3, a streamlined bar exam. We would have to say, right, a bar exam that is comprised of 100 or 120, whatever you all decide, multiple choice questions and this number of performance tests. So I just want to make sure that we are working toward thinking about what information you need in order to come up ultimately with that recommendation. You are not, I repeat, not being asked to make that recommendation today. When we present the cost benefit analysis to you, that you will be making that recommendation at the time. If there is one of the options that has discussed that you all think is ridiculous and we should take that off the board, not even include that in the cost benefit analysis, that's also obviously something that you should discuss. And with that, I'd recommend taking the presentation down so we can see each other more completely.
Alex, I've
Yes,
got,
Mr. Kramer.
should I just roll through that?
Sure, please.
Okay, let me share my my document here. Okay, so it begins with just a recognition we're being asked to do this fast. Too fast in my estimation, but we really don't have a choice. We were given a bit of a choice though with Donna's new news today. And Donna, I want to ask that you post the revised slide deck to the agenda so that we all have it for history.
Of course.
We have more time, so we should talk about whether we need to decide in October. I'm sure the preparation of the cost benefit analysis could benefit from more time. So let's go through the list here. We've touched on some of it. You can read along. I'm not going to read it. I'm going to try to summarize it. Bethany already mentioned learning the lessons from February before embarking on another remote exam. I think that's one of the principles. And I'm wondering when that process is going to begin. Responding to you and others, Alex, I do not believe that simple faith that technology will eventually solve the problems is enough in this environment where we can't afford to make more mistakes. Our exam is so unique in it's the number of people taking it. We need to know what went wrong and whether it's possible. We had a vendor who said all the right things, looked polished, and completely failed to deliver on the promises that they made to us. It was an absolute failure, I believe, of technology, but again, I don't know. And then in some of the discussions, the chart that compares the proposals to the principles, some of the principles are dismissed as being, quote, more about implementation than exam selection. Come on, if we can't implement it, that's a big problem, isn't it? To just dismiss that element on those grounds, I think well, I do not buy that. I cannot accept that, especially after February. And as I think I said a little earlier, less weight should be given to the future possibility that we can conduct the exam remotely. Transparency is a core value. Moving as fast as we are, can we pay more than lip service to that? I really wonder. If we're talking about having more than 2 exam administrations per year, at what point do the costs, developing new, you're gonna have to have different essay questions for each exam administration, getting the graders together, and all the calibration sessions. There's some benefits in doing things in high volumes. And so what point would those costs become prohibitive? And what about the psychometric validity of an exam? If you have an exam where only 200 or 300 people take it, can you psychometrically calibrate that and scale that to our standards? I don't know. Obviously, a consultation with our psychometrician is in order. So I consider those 2 supposed benefits to be pretty speculative. Option 3, I still don't know what it is. It looks like it's a 1-day exam. That's a pretty radical change. In the last 10 years, I think we went from 3 days to 2 days. And to now in just 2 years, come up with a 1-day exam that's going to be psychometrically valid. It's going to be enough time to test for a broad range of knowledge and skills. And it's offered as the replacement for the new bar exam that we were expecting to take 5 years to develop. Given all the uncertainties of that, somebody asked earlier Donna, I think if I would jettison one of these, and I would take option 3 and draw a big black X through it. I just don't see that as worthy of our time and efforts at this point when we're up against these deadlines. Do we have a contingency plan if something goes wrong? We went all in on February 25 without an alternative, and story tells itself. Choosing the next gen exam allows us to leverage the NCBE's work. They've been working on it for several years now. They're pre-testing things. They will have been battle testing it in those states that are choosing to implement it in the next few years before we would implement it. Why reinvent the wheel with some sort of California exceptionalism theory that we're so much different or better than everyone else that we can't use the same bar exam that they do? Maybe there's a reason for it. I've never heard one. if after a few years it doesn't work for us, then we can work on another exam with the breathing room to do it right. Do we know if NCBE is considering remote testing for some future time? I thought Alan told me once that they were talking about it, but I could see why, even without what happened to us, that they wouldn't want to do that at the same time they're rolling out a new test. Let's get that thing working right, and then we can talk about the way to administer it, an alternate approach. The information from Mr. Cohn that they would allow it to be given remotely if it's necessary to provide an accommodation for a disability. That suggests that there is a little bit of flexibility on their part already, and I would imagine if they got more comfortable with it and the ability to secure it, they might open up even further. But we need to first get our replacement right before we fool around again with remote.
Sorry, Paul, was that a question about NCBE and remote testing in there? Or
Go ahead.
I didn't mean to interrupt. Everything that's published that we know is that the next gen is going to be administered in jurisdiction-run facilities. And even if there was remote testing that a jurisdiction approved as an accommodation, that would require a live proctor, not a remote proctoring system, if you know what I'm saying.
Oh,
The
okay.
live proctoring is required.
Proctor on site.
That's right.
So we may have to send them to one of these small testing centers. Okay.
Which isn't allowed by them. It's all jurisdiction-run facilities. Sorry to interrupt you.
Okay, that's fine. But my point is, I don't know if they're just waiting to do take one step at a time, one foot in front of the other, and that they would be open to remote testing at some later time.
There was a recent article in the ABA Journal where that question was posed, and a clarification to that article the next day, because the first version made it sound like they were more open to remote. And essentially, I think a summary of that article might be, sure, they'd be willing to consider it in the future if the technology gets to the point where they are comfortable with that it protects the security of the exam and the integrity of the exam, but it doesn't seem like it's anywhere on the near horizon.
And is that possibly because the technology isn't ready, as we discovered in February? The charts suggest that only a California passing score on the next gen exam would be transferable to other jurisdictions. But I think it's the case that if their score is below our cut score, but above some other jurisdiction's cut score, then they could take our score to that other jurisdiction and become a member of their bar. That's a minor quibble, but nonetheless, I quibble. Staff has mentioned the staff competence as tested designers. Yeah, I have my own questions, and even if we contract out the design, we still have to administer the contracts. We cannot treat those as a black box and just, well, to our peril or at our peril, we could do that. But then when they screw up, we're going to have to clean up the mess. And I don't know that you can get reputational egg off your face very easily. We're now giving more attention to the applicant's convenience as a motivation for their remote exams, but the initial impetus was purely just saving money. If remote exams were more expensive, I don't think we'd be having this conversation at all. The incomplete pro and con lists, which as staff admits, are not ideal for us to make such an important decision. A little more time, which it sounds like maybe we have, would allow for them to be improved, I suppose. I wonder if we can't, given that one of the concerns is that we have wasted money on the Kaplan contract unless we use them. I wonder if they can't be repurposed to, for instance, prepare the California specific add-on content that we might want to have to add to next gen, or to prepare first year law student exam questions to recoup some of that investment that we've made. In the cost benefit analysis, I would like to see the numeric calculations come to us in the form of a live spreadsheet. Not necessarily that we all get to play with it ourselves, but if we're questioning assumptions and changing assumptions as we're discussing that part of the analysis, it would be nice to be able to plug in a new number and immediately see the results rather than finance having to go back and, you know, report back later. And estimating costs, don't forget bar staff time, a factor that generally hasn't been accounted for in past tallies of costs. If you went to a test site this July, you met relatively highly placed, highly compensated members of bar management there to undertake the dual role of, you know, managing the test centers. Those costs need to be factored in. And I'm wondering if we went to the next gen exam, would we have to have less staff? Some functions would no longer be undertaken by us. So what would those savings be? And then a couple bigger picture questions not to be discussed today, but I just throw them out. How much bandwidth do the board members, do we as individual CBE members have for oversight? I'm retired, and this is kind of a hobby for me. You know, and I'm sure other people have less time to give to this. But also a corollary to that is, do we meet frequently enough so that we can effectively provide oversight? Or give ourselves the time to fully discuss the matters that are before us? And finally, how much should be delegated to staff versus we're digging into the details? I'm at best a trust but verify person, but just, you know, just handing off the responsibility, I don't think is, as far as my values go, that's not doing my job as my volunteer job as a member of the committee. Thank you for your indulgence. Donna?
Thank you, Mr. Kramer.
So, so Donna, what I'd like to do, I'd like to look over to you to see if you have any response to any of the either assertions raised by Mr. Kramer or, you know, if there's any answers that you can give to some of those bigger questions. What I would anticipate doing is incorporating some of these concerns into that cost benefit analysis without going through, you know, a point counterpoint discussion right now. You know, I really do thank Paul for, you know, his detailed analysis, but also mindful of, you know, making sure that we use this body's time correctly. So I don't think that there's broad disagreement on some of the, you know, some of the issues that Mr. Kramer brings up, but, you know, I think this could really, you know, it could suck a lot of the time away from the rest of our discussion, which it's 12:15 right now. We're agendized to go through 2 o'clock. So we kind of need to keep the show on the road. So Donna, briefly, do you have any discussion on these items?
So, there were some things that were kind of posed as questions. There are a couple of factual discrepancies, but I do agree with you that, you know, unless sort of they come up sort of more as we are all talking about, you are all talking about the various options, you know, I can address them at that point. Otherwise, I would happily incorporate responses as appropriate into a cost benefit analysis to make sure that we are touching on all of those different aspects as we're thinking about, as you all are thinking about what to recommend moving forward.
And any discrepancies that you want to respond to right now, or you okay waiting until next time?
I think let's go ahead and move forward.
Okay.
And Mr. Harrison, you have his hands up, I believe.
Yes, I just wanted to flatly state that I respectfully disagree with Mr. Kramer's questions, solutions, and assumptions. I mean, I just went on Google right now and found over a dozen online test providers that could be used to provide an online testing platform. And as a member of this Board of Trustees, in discussing what a future bar exam would look like, and also including myself as a member on the Blue Ribbon Commission, my focus was on the applicant, on the student, on the person trying to become an attorney. It was on the fact that there are economic impediments for a lot of people when it comes to taking the bar exam, and how a remote option could significantly remedy that issue with respect for these folks who struggle, who don't have the resources. And so because the NCB essentially flat out rejects a remote option, and because the NCBE will not allow the bar exam to be delivered more than twice per year, which I also think factors into the analysis when it comes to a test taker who maybe passes, or excuse me, who maybe fails the exam for the first time and needs to retake it and has a job hanging in the balance that will allow them to earn a livable wage. There needs to be a future where we can offer an exam more than twice per year. Also, I don't like being handcuffed, right? The NCBE appears to have what is close to be an monopoly on this bar exam deliverance. And I don't want to be in a position where the state of California has to follow what the NCBE tells it to do when it comes to delivering its bar exam. And if we commit to staying with them, there is what I call atrophy with respect to other people who are able to develop questions and deliver bar exams, like expert atrophy in that field that will occur over time. The more and the longer we rely on the NCBE to deliver these multiple choice question products. And there's also an assumption that the NCBE is going to provide good questions. I mean, they're not going to provide the same questions for every bar exam, and they're going to provide experimental questions. They may be bad questions. And so we're assuming they're going to deliver a good product, but we don't know for sure. And so I just wanted to point that out as well. That's all.
To be
Thank you,
clear,
Trustee
I'm not
Harrison.
against remote. I'm simply think it's going to be very difficult to do.
You know, recently the law school deans certainly have written us a letter, and I've reviewed and scrutinized the letter. I want to just make a quick comment. And for everyone who has raised the option of adopting the next gen, it's certainly one of the major pathways under consideration. And I appreciate again the intent to align with a national standard that's been in development for years. But it's also equally important to acknowledge that adopting next gen comes with a lot of real constraints that may not align with California's priorities or even the needs of our diverse applicant population. For starters, I think Mr. Trustee Harrison sort of mentioned this before. Next gen doesn't offer a remote online administration option, and there is no confirmed timeline for when or if such an option will be made available. And Ms. Hertzkowitz already confirmed that. And so the lack of flexibility sort of stands in tension with California's recent experiences and ongoing efforts to increase accessibility. Also, another thing you want to think about is next gen doesn't really test California-specific topics, including a lot of subject matter that our Supreme Court and the legislature sort of still consider essential for ensuring minimum competence in California. And so, under the current model, we would lose that ability to assess state-specific laws unless we bolt on an entirely separate component, which may undermine the very efficiencies and simplicity of the next gen promises. I don't want to beat a dead horse. I think all of us understand the constraints and a lot of things that we have to think about. I'm not going with one or recommending against another. I just want us to have an open and honest discussion that all three options have their own constraints. And I don't think it's time for us to make a decision. It's a very good, thought-provoking discussion that I want us to keep in mind. But I also don't want to hold the horse, especially when lunch is already here. So, Chair Stallings or Ms. Hotskos, should we move on and continue and get agenda item 2.3 completed as soon as possible?
Brennan, you're muted.
I do want to acknowledge a couple people who have raised their hands. So
And I'd like to get
I
on.
understand there's an issue with San Francisco and their lunch. Have you guys resolved that?
No, I don't believe lunch is here quite yet. Oh, it is. Okay, thank you. It is here. Thank you.
It is, okay. So what I'm gonna do is I'm gonna take Trustee Tony and then Miss Messawala, and then we'll go grab lunch, reflect on this, and then come back. Does that sound good? All right, so Trustee Tony.
I appreciate a great deal that we are given a chance to discuss an issue and not vote on it at the same meeting. I find that very valuable for my thinking. For us to consider, for me to consider moving forward with an online testing, I was the one that said we need to learn the lessons from February 1st. I do appreciate the fact that Chair Chan brought up one of the lessons, which is avoiding long-term contracts. That's only one of the lessons. I think there are many. We have not had that discussion at all. And I see no timeline. I've seen nobody with a timeline for it. The other thing I want to know is I want to compare what we're looking at in terms of the licensing of attorneys and the in-person versus online testing, which I'm very open to. But I want to find out what's happening with parallel professional licensing. What's happening with medical licensing? What's happening with CPA, CFA, engineers? There may be others that are parallel, but it would help me make a better decision if I understood better. And the other thing, and this is not to be explained today, but before we come back, is I want to learn more about the Nevada plan. I don't know anything about it other than what was discussed today, which is not very much. I want to know who their vendor is, things like that. And that'll be enough for today. Thank you for this discussion.
All right, I think staff will definitely incorporate that. Ms. Messawala.
Realizing that I am the only thing that stands between all of you and lunch, I'm going to keep this very short. I just want to remind everybody of where we sit. We sit in California, right? And California is the world leader in technology. And I truly believe if we do not offer robust remote options, we will lose credibility with the public and we will lose credibility with all test takers. So thank you.
Thank you, Justice.
Brandon, before you break, if I could just make one point, which it's, and I think I would sort of focus back on one of the guiding principles, which was adopting an exam that allows you the flexibility for in-person and remote, because the decision about should we go remote absolutely does not need to be made right now. Or even with the cost benefit analysis, right? We are creating the decision, the recommendation that you all will be making would be sort of the exam on the exam development side, as opposed to sort of the exam administration side. So we, and so one of the things that I think I got from the board's prior discussion of guiding principles was we may not be ready to go remote just yet, but potentially thinking about an option which allows you the ability to switch to remote at the time you all determined that we've done all of the due diligence that we need to make sure that we are ready for that. So I just want to make sure that we're not thinking that the decision that we make soon has to be, is it going to be delivered remote or not? If the decision is, as we've all been speaking, next gen UVE, then that question, that issue is out of your hands. And for the foreseeable future, it would be an in-person administration at state-run, jurisdiction-run test sites. And so I do wonder, Brandon, before you break for lunch, should we ask CBE to take a vote on the guiding principles, and then do the break and then come back for further discussion of the options?
Yeah, I think that makes a lot of sense. So I'll hand it back over to you, Chair Chan, on any such motion.
Thank you, Chair Stallings. Donna, do you have the resolution that you can put up?
There is a resolution.
Mhm.
Do you want to revise it? Let me just scroll to it here. And then add my note. Okay, Devin, if you can share the screen, or Sharon. So that is the revised resolution.
Great, thank you. With the resolution, do I have a motion from the CBE members?
I'll make a motion. Ashley Silva Guzman.
Thank you.
This is
Any
Becky.
second? Moved by Ashley, second by Ms. Peak. Any additional discussion or comments? Hearing none, Ms. Farland, please take roll.
Holton,
No.
Cow, not present. Gongora, not present. Kaplan, not present. Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy Walla,
Yes.
Montgomery,
Yes.
Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna, not present. Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 9 yeses and 1 no, the motion passes.
Thank you, Ms. Farland. Pass it back to you, Chair Stallings.
All right. Interim Executive Director Erica Doherty had a great idea to see if there was any appetite on the Board of Trustees to adopt such a similar guiding principle. So is there any appetite from the board? Would the board like to make such a motion? Trustee Tony, I see you looking askance or something.
Maybe I missed this part of the agenda.
It's So it's not on the resolution, but this, because it was generated out of the CBE discussion, I think there might be some benefit in having, alignment of both the board and CBE's guiding principles.
It seems like we already voted on it. It's pretty close. I mean, it's not like we did different principles.
I think, Trustee Tony, just to clarify, I think what we would be asking is the only modification is what was in the resolution on the screen to add that avoidance of long-term vendor contracts to provide flexibility. So it'd be to amend it to add that to the existing guiding principles that now CBE has adopted along with the board.
That is only one of many lessons we need to take from the February exam. I'd rather do all of them at once. That's my opinion. I'm not in favor of doing it piecemeal. I want us to have a discussion and adopt all of the lessons from February exam at once. I'm unhappy that we have not done so yet.
Understood, and I also understand that we are pending the results of various audits and investigations directed by the board. So I think that we do need to, have those completed before we potentially take steps that you're talking about, and would also just cite back to, the various reforms we put into place already. But if there's no appetite for the board, I'm not going to also stand in the way of lunch. So we'll table the rest of the agenda until after lunch. We will return in 15 minutes at approximately 12:47. Hopefully that'll give everybody enough
Chair
time to
Stallings,
grab lunch.
I'm sorry to interrupt you. I think we are still waiting on LA lunch based on what information I've just received.
Okay. All right. And this is without the LA Olympics jamming up stuff. So let's
All right, late breaking news. It is now here.
Boom. Perfect. Okay.
Apologies.
12:47. See you guys back. It is 12. We'll call the meeting back to order. It's 12:50. Working through lunch here. The only thing that I see left to do on 2.3 is to see if we're going to basically jettison any of the three options. What I'm hearing is that there's fairly vocal opposition and support for option 3. I think that deserves further analysis before deciding, for or against at this early stage. So what I would propose doing is having all three options be evaluated by staff, given the cost benefit analysis. Certainly, we can look at things such as the LA Olympics and their impact on the 2028 exam, potentially building in cost benefit analysis of going to a smaller but mid-sized city such as Bakersfield, where we have copious convention center space and is fairly geographically close to LA. But I digress. Don't want to talk about how great Bakersfield is in front of y'all. But I think that staff has received some really good direction from this group. Donna, is there any other direction as to these three options that you believe you need before we move on to item 2.4?
I am open to any other suggestions, questions, options, but I can proceed, I can absolutely proceed with what I've been given today.
I had one, or a few points, just to add to the list. I think that I would like to see the psychometrician information about their ability to accommodate a half-day exam for option 2. And honestly, for all options to see, it might just be helpful to have Chad there at whatever meeting we're making that decision. I'd also like to figure out what all the options look like as far as our Kaplan contract, whether we can place them on hold, are they working in the interim to create these questions, what a new contract would look like to continue the creation of the exam topics if we go with option 1 or 3. And then lastly, if we can also tee up or look at, I know we had previously discussed new subcommittees for examination design and all of those things, what their role would look like in any of these options 1 through 3.
Got it, thank you.
I have a question just about timing. With the new news we received today, should we be trying to decide this in October or give ourselves a little more time?
That's a question for all of you. Right, so are we looking to provide notice by February, so meet the timeline we'd originally set out, that would allow us to switch to whatever it is we're going to recommend and the Supreme Court would adopt that we switch to for February 2028? Or do we move that timeline, continue with the MBE and California developed essays and PT through and including February 28 and move to something new July 2028?
I think from my perspective, I think time is still of the essence, given the various orders and timing of everything. So unless staff feels like you're not going to have sufficient time to provide that data, I say we continue on that accelerated timeline. Trustee Grande?
I think one concern, and I think if that could get addressed, I do think we should push for a sooner deadline and know that we have that additional time. But if we did do a change in July 2028, and given that we've talked about the Olympics, all of that, those kind of things, I would want to know what the July 10th is the bigger population of exam takers. I would just want to know how those factors would impact a rollout. I think that's an important piece of information as well.
Definitely. Trustee Tony?
Thank you. I think it's very important that we give ourselves as much time as we can, and that it would be a mistake. I think part of what happened with February is we made decisions too fast without knowing enough things. And if we have an extra 6 months, let's give ourselves the extra 6 months to really incorporate and learn the lessons so that we make a fully informed decision. I think it's a mistake to rush into it when we don't have to.
This is Julianne Smith here. Just two smaller points that I'd also want to, I guess, have considered. If we do option 3, is there any consideration over time to start to fold in some of the test development jobs into the state bar and have those as employees versus outsourcing everything to a third party? You know, as far as, is that a good idea? You know, feasibility, and if, you know, if there's any cost savings or what the cost effect would be. And then also with issues at proctors at third party sites, would we want the board, the state bar to have proctors who are trained by the board, not necessarily employees, but, you know, board selected and hired versus just having the proctors at these third party test centers proctor at who might not have the appropriate training for the bar exam specifically, and kind of taking those into consideration as well. That was my comment.
Any other comments? Okay, I don't see any. But certainly I want to be, sensitive to the issues that Trustee Tony raised regarding timing and giving us, as much time as possible. I think that what makes sense to me at this meeting is to continue on our, march forward to have a plan. Certainly if there's a decision to contract with NCBE to give us a little bit more time, I think that can absolutely factor into the matrix, but having a shorter leash on this issue, I think is better than a longer one. So I'd prefer to keep the shorter leash at this time, understanding that it could, the ultimate decision could kick down the road just a little bit more. Do we need a formal motion for any of this? I'm looking to Aline or Donna.
Donna, I think we were looking for consensus, right, Donna?
Yeah, I mean, it might be helpful, frankly, to have somebody make a motion on, are we moving on the current timeline that would allow for implementation, the current timeline which would allow for notice by February 2026, or right, so either a motion to do that or a motion to push out the timeline that would allow for notice by July 2026. I think would be helpful because there are differing opinions here, and I want to make sure everybody's opinion is getting considered as part of this.
And would we proceed with Committee of Bar Examiners taking that up first and then a motion by the Board of Trustees?
Yeah.
All right, great. So I'm going to hand that over then to Chair Chan.
Thanks, Chair Stallings. Do I have Donna, do you want to put up the resolution?
Hang on, we've got to add it here. So this one was not agreed to. I'm sorry, I don't know why it's in.
I would move that with whatever date you need to aim it at the July 2028 exam. So for instance, you could maybe bring it back to the CBE in December. That would give you more time to prepare an analysis that, is more likely to allow us to act then. And then, so I don't think we don't want to push up against the new extra 6 months we have entirely, but we should take some of that time for ourselves. And this gives more breathing room to the staff, and then to educate us and inform a decision that we'll feel more comfortable with.
So I've said that that would, without sort of getting to the interim timelines within there, right, a timeline that would allow the 2-year notice of changes to the bar exam to be provided by July 2026. That doesn't mean we take that time, that full time, that we could still work on when we would get something to the CBE, when we would get something to the board, but that's the way I've interpreted that motion, Paul.
Yeah, but my expectation is that we don't rush to decide in October now, and
Right.
then just sit on it, or the court doesn't need 4 or 5 months, I don't think, to act. So moved.
Thank you, Mr. Kramer. Any second?
I'll second the motion. This is Vince.
Thank you, Mr. Reyes. Additional comments, discussions, or debates?
This is Bethany. I support the motion. I just want to, I guess, a comment is that to the extent that we could, I don't want us to rush, as we've already discussed, right? But I think that it is better for us to try to make as much progress before this year is out as possible, so that all of the, this extra 6 months we have, that is more time just for, the development and the fleshing out. I just don't want us to wait and not, submit anything to the board until like January or something like that. That's my only comment.
Thank you, Ms. Peak. Point well taken. Any additional comments or input from CBE members? Hearing none, Ms. McFarland, please take roll.
Bolton. Bolton.
Yes.
Cow, not present. Gongora. Not present. Kaplan. Not present. Kramer.
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla.
Yes.
Montgomery.
Yes.
Peak.
Yes.
Silva Guzman.
Yes.
Smith.
Yes.
Reyna, not present. Reyes.
Yes.
Yokelson.
Yes.
Chan.
Yes,
With 10 yeses and 0 nos, the motion passes.
thank you. Back to you, Chair Stallings.
I think you're muted.
Thank you. Is there any corresponding motion by any member of the Board of Trustees?
So moved.
Okay, first by Trustee Harrison, do I have a second?
I'll second.
Let me just finish writing it.
And I'm sorry, who was the second?
Tony.
Trustee
Oh, Trustee Tony.
Mhm.
Okay.
Right. Trustee Harrison, is that language in line with your motion?
Yes, it is.
And then Trustee Tony?
Yes.
Great, thank you. Madam Secretary, can I have a roll call vote, please?
Barahona.
Right.
Buenaventura.
Aye.
Cisneros.
Aye.
Good, not present. Gore.
Aye.
Grande.
Aye.
Harrison.
Aye.
Huser, not present. Soel.
Aye.
Stevens.
Aye.
Tony.
Aye.
Trejo.
Aye.
Stallings.
Aye.
With 11 ayes and 0 nays, the motion carries.
Great, thank you. I'm going to turn now to item 2.4, and Alex is taking this item.
Thank you, Chair Stallings. Item 2.4, which is discussion and action, if appropriate, on bar exam fees and other admissions fees for 2026 and 2027. This item, I believe, is being presented again by Ms. Hartskowitz and also our Chief Financial Officer, Ms. Montoya Chico. Take it away.
Thank you. I'll just wait until Ms. Montoya Chico is promoted. Okay, so as we've been discussing all morning, the requirement to conduct an in-person exam at state-run test sites for the next, I'll now say 2.5 years, at a minimum has had a significant impact on the admissions fund, returning us to operating at a deficit and eating through the fund's reserves. At the July 3rd Board of Trustees meeting, staff shared preliminary estimates that the admissions fund is now projected to have a $3 million deficit for 2025 as compared to the $3.2 million surplus that had been projected in the adopted budget. This was a result of refunds, reimbursements, and decreased revenues due to withdrawals stemming from the February bar exam, as well as the need to switch to large in-person test sites for the July administration, and switching from the originally budgeted for remote and small test sites for July. The projection, based on the information that we currently have, and we have not currently logged all of the receipts from the July exam, but the projection based on information we currently have that was told to the board at the July meeting is that by the end of 2026, the reserve in the admissions fund would shrink to approximately $900,000 and to $400,000 by the end of 2027. As a result, we've determined that we need to advance the 3-year review, the triennial review of admissions programs fees. It was originally intended to be conducted in 2026 to be effective largely for 2027 and going forward. We have determined that we need to advance that review so it would be effective for 2026. For those of you who were here in 2023 when we adopted the fees for admissions program fees, as well as fees for some general fund programs that had not had fee increases in years, you'll recall that the review of those fees includes an analysis of the revenue and expenditures associated with each program, which includes the allocation of personnel costs to each of the programs based on staff resources that are devoted. So for example, in determining how much it, and this is actually responsive to a public comment that was made earlier, in determining how much it costs to administer the bar exam, in this fee analysis, we looked at all of the expenditures that were associated with putting on the bar exam. That includes the staff time and the resulting personnel costs that are associated with the bar exam. Historically, when we had done a cost analysis, we had not added the staff costs or a division of the personal services costs to each program. We were just looking at things like for the bar exam, how much it costs for the test sites and for the proctors, but not looking at the staff allocations as well, which is what added some significant cost to it. Doing that work takes time because it's not how our budget is structured. And so it requires a substantial amount of work to align the expenditures to each of the programs. By programs, bar exam, application for bar exam, moral character, special admissions programs, first-year law students exam, etc. So we realized originally our chief financial officer came up with a very aggressive schedule to complete the analysis and be able to return to you all in September. And we just realized that that was not feasible to get the analysis, the detailed analysis fully completed in time to get the necessary input from the Committee of Bar Examiners, from the board's finance committee and the board by September, which would be in time for the registration for the February 2026 bar exam. So registration for the February 2026 bar exam opens on October 1. In order to have fee increases in place that would apply to the February bar exam, we would need to adopt something, you all would need to adopt something in September. So we're not going to have that full analysis complete. We are proposing that the committee and the board approve an increase that would apply just for the February bar exam at this time. We will return in November with a recommendation for the more comprehensive changes that are needed to all of the program fees in order to right the ship and to get us to the point where we have not completely depleted the reserves and are not continuing to operate in a structural deficit. The staff report identifies 3 options. Raise the fee for the February bar exam by $150 today at this meeting. Defer the decision to raise the fee for the February 2026 bar exam until September, giving a little extra time, or not raise any fees until the more comprehensive analysis is complete. Staff recommend the first option. This will essentially be a stopgap measure until the more comprehensive analysis of the review and expenditures can be completed. The $150 recommended is less than we believe will ultimately be necessary, but is more than it would be if we just increased the fee by the Consumer Price Index, which, if you'll recall, was the understanding with the triennial review that in the intervening years before we did the each 3-year review, the fees would increase by the Consumer Price Index. I'll remind you that at the July 3rd board meeting, finance staff provided a very rough estimate of the increase that could be needed for the fee to sit for the bar exam in order to address the increased costs of bar exam administration. That estimate was $280 for non-attorneys and $550 for attorneys. I'm telling you this not because that is the number. The final number will obviously require, as I said, the more comprehensive analysis, potentially offsetting some increases to some fees with higher increases to other fees where that is appropriate. But I'm sharing that number just to say the $150 that is being proposed here in option 1 is less than sort of even that rough estimate amount that staff had provided to you at your July meeting. With regard to option 2, we simply don't believe that there's going to be much better information finalized by the September board meeting to help you make the decision. And there certainly won't be any better information by next week's Committee of Bar Examiners meeting. And obviously we could have another special meeting, but we just don't believe that there will be more information, significantly more information by September. So waiting until September doesn't make the most sense to staff. But with regard to option 3, we don't think it's wise to lose the opportunity for additional revenue to help staunch the bleeding, which we could get by imposing an increase for those applying to sit for the February exam. So staff doesn't believe that option 3 is the best way to go, because we would lose the opportunity to get at least some revenue bump for the February exam. And with that, I will turn it over for questions.
Comments, questions from any CBE members or the Board of Trustees?
Yeah, it's Paul. So Donna, the projected $3.2 million projected surplus in the adopted budget, was that strictly taking into account the revenue and expenditures for the year? It had nothing to do with the existing reserve?
I'm going to let Araceli speak to the specifics of any of the budget numbers.
Good afternoon, Board of Trustees members and CBE members. I don't think I've had the pleasure to meeting any of you today. So to answer the question, the surplus that we had initially projected in the adopted budget was the entire admissions fund. It included the bar exam, which is the main program, but it included all of the revenues and expenses of the admissions fund was intended to revenue earned and expenses expended. The surplus would have just been added to the reserve that we had projected. Anytime there's a surplus in any year, that surplus or deficit is either getting added to the reserve or it's eating from the reserve.
Okay, so we were charging more, we were trying to rebuild the reserve in effect by charging more than our actual expenditures.
Our reserve policy that is set is to be approximately 17% in any given fund. We were trying to build up the admissions fund reserve. 2025, when we had projected the budget, we were anticipating it to be the first year where the admissions was finally going to be in a surplus position. And it was largely because we did raise the admissions fees that had not been raised for multiple programs, not just the bar exam, but we finally raised the fees to probably the levels that they should have been. And that helped augment the revenue to help offset the expenses that had been going up, and we hadn't really had any fee increases for a while. So that really is what drove the original surplus positions and the forecasted also surplus that we adopted in the 25 budget.
Okay, I'm hearing yes. When we went over I'll admit, we were consulted about the fees back in 2023. And, the budget was in crisis. That's when we learned about it. During that exercise, which I participated in, both as a part of a small working group and then on the committee, all of the fees were presented and expenditure estimates were presented to us in the form of a spreadsheet. Again, a live spreadsheet like I referred to earlier, so we could then, if we wanted to work with the numbers, we could very easily do it and see the results right away. So I hope that same tool will be available to us when we are looking at it in the next few months, whenever it comes to that.
And yes, we will have the Excel spreadsheets certainly available.
Sorry, just to clarify, this is Julianne Smith. So the $150 increase, would anything go towards the reserve, even though it's less than the suggested 17% minimum? Or is that just like the just getting back cost at that increase?
At that increase, it's really just getting back costs.
Yeah, I think we're pretty underwater because of what happened in February. Otherwise, we'd be really slapping ourselves on the back and happy.
Mr. Chair, I have a question. This is Vince.
Hey, Mr. Reyes.
This is to Donna. How much, if we were to raise the fees by $150, how much notice do test takers get?
Donna, you're on mute.
Muted.
Sorry about that. It's another reason, Mr. Reyes, to make the decision today. If you all make the determination today, then we can post that almost immediately. So the February test takers would be told what the amount of the fee will be that they would need to pay when they register for the exam, and they'd register for the exam anytime between October 1 and January 1. And so the more notice that we can give them, the better. When we raised the fees in 2023, we had posted notice on our website as early, I believe, as July, and we said, this is the proposal that's going to be going to the Board of Trustees. Staff are going to be recommending this amount. Until they adopt it, it's not final, but we want you to be prepared that this might be coming. And that was the way that we could give as much notice as possible, because in 2023, the board adopted the increase at the September meeting, which would take effect October 1 for those sitting for the February exam. So this would give us the ability to provide that notice right away.
Thank you, Donna.
I want to be candid. The situation we are facing with the bar exam cost is in part, I think, the results of our own mistakes. Unfortunately, those choices now have a real financial impact, and that impact is now being shifted to the very people we serve, which include the applicants. And so, I know we haven't really talked about this, but I am disappointed that we have reached this point. The last thing any of us wants to do is to add to the financial burden of aspiring lawyers, many of whom are already managing a lot of debts and also personal sacrifices. But the reality is also this: without an increase in exam fees, we will not have the resources necessary to administer the bar exam in the long term at large scale in-person venues. And this is obviously not an optional expense. It is essential to keeping the admissions process running. That said, I encourage us to explore ways to really mitigate the immediate hardship. For example, can we offer installment plans so that applicants pay part of the fee at registration and perhaps the remainder closer to the exam dates? Can we allow a multi-stage payment structure so that the upfront cost is less daunting, right? These measures could help bridge the gap between fiscal responsibility and also compassion for those who are entering the profession. I still remember when I was taking the bar exam, the fee was so skyrocketed that I actually had to find ways to pay for that money. And obviously, many years later, we're looking at thousands of dollars. And so we really, need to think about this carefully. If we must raise fees, let's at least do it with a clear acknowledgement of the burden we're imposing and with some tangible options to at least lessen that burden where we can.
Chair Chan, you have a couple trustees with their hands raised. I don't know if you can see them.
Please, Trustee Saul, and then Trustee Tony.
Appreciate the discussion here, and Araceli, a couple questions just around sequencing, and Donna around sequencing. If we do this now, this is for the February bar exam, but in the intervening period for the July exam, there would be new data that would be coming forward. So from a sequencing standpoint, the cost of the July exam could be, for those applicants, could be even higher, or will be even higher.
Yes. Yes, once we determine the fee, the likelihood is that it would be higher than even the 150 today.
Okay. And the 150 today, I think, Araceli, you and Donna have characterized this as more of a bridge. Is there anything that we can do based on reserves that we might have? I know our budget is already very, very tight, as a finance chair and as those that are on the finance committee recognize. But is there anything that we can do that would help to sort of mitigate this for both the February applicants as well as the July applicants as we sort of wrestle with the overall sort of fiscal situation?
As Donna mentioned, we have presented preliminary or numbers that based on data that was known at the time. I believe the July board meeting was the last one, and that's the admissions fund will be in a deficit position this year. That's a fact. Yes, there's reserves to get through 2025. We are literally in the process of redoing the admissions budget. I don't have updated numbers, but for right now, yes, it will continue to be operating at a deficit this year. Is it going to be the 3 million that we had initially seen? No, it'll probably be a little bit better, but nonetheless, it'll be a deficit position. So for 2025, yes, there's reserves. For 2026, which is when all of the bar exam fees would be raised. There probably is, I think we had forecasted, if I could look really, if you could give me a minute, to have reserves for 2026 as well. And that was under the assumption that fees, and Justin, I know Justin's out listening. If you're out there, I believe we did it under the assumption that the revenue would be what it is, meaning the fees would not be raised. But again, we haven't looked at the entire admissions fund. Yes, that's correct. I was told that's correct. So thank you. The fees would be, basically what they are, just with the CPI increase. The reality is that any little significant expense is going to completely eliminate the reserve. The admissions fund does not have much reserves left through 2026. So it'll be very, very important into 2027. There are no more reserves come 2027. If we don't get ahead of that now, and something happens again, we had forecasted a surplus position in 2025 and it completely flipped to a deficit position.
No, understood, Araceli. I think, and I appreciate you going through the admissions fund. I actually think I was thinking broader. Are there other funds within the board's budget that potentially could help to mitigate some of this?
I think at one point, and that might be a policy decision, and I don't know what else, Donna, maybe if you happen to know, whether the general fund could loan money to the admissions fund. But again, it still goes back to, we still need to build the admission fund reserves, and fees would probably need to be, they're going to have to continue. If we don't raise fees for 2026, they're going to have to be higher for 2027 is the reality, right? You're just pushing it out.
No, I understood. I guess part of this is ways to try to mitigate this, as well as just that discrepancy, which will be probably very significant between those folks that take the February bar exam and those folks that take the July exam in 2026. There's going to be, I think, a pretty good delta between those charges, and just looking for ways to try to mitigate that.
Trustee Tony?
Thank you. I'm going to ask a couple questions, then I'm going to share a few thoughts. So my first question is, if we were to approve an increase equivalent to the past 2 years CPI, how much would that be?
I think, Mark, I have it here. So right now we have $850 for students and $1,500 for attorneys. The CPI that we're going to use hasn't come up, but roughly it's been 3%. That's only $26.45 about.
Okay, thank you for that information. The second question is, what was the amount of the increase adopted in 2023?
I don't have that handy, but if you give me a second.
The increase was significant. It was a 26% increase for non-attorneys and a 53% increase for attorneys. So it was a significant increase.
So let's talk about that. I really led the campaign to increase the admission fees, and not just the admission fees, but all the fees charged by the state bar. The state bar's two main sources of revenue. There's others, but the two biggest ones are the attorney fees that are decided by the legislature, and there are fees that the state bar determines. And we had complained for many years, there's only been one increase for 25 years or whatever, right? From the legislature, okay? Bar fee increase. And when I was serving on the finance committee, I asked a lot of questions, and it turned out that many of the fees that the state bar charged for exams and for law school certification, things like that, had not been increased in 5 years, 10 years. Sometimes nobody knew how long it had been. And part of my thinking is that for us to have credibility with the legislature, about they need to, pass an increase. We needed to do our own job and make sure that we also, and what turned out when we did an analysis is that nearly every fund was running at a deficit. It was not paying the cost that it was supposed to. These are supposed to be self-sufficient. So in 2023, and I think this is significant to, for you to reflect upon, in 2023, when we adopted these enormous increases in the fees for the bar exam, they were based on the assumption that the bar exam would be in person. In 2023, we were not talking about online. That was not part of the calculation. And I'm saying it because I'm having a difficult time understanding how we've gotten behind so far because we didn't take into account savings from online. So it seems like the deficit that we're experiencing is due to the one-time February exam fiasco, which is our fault, and we have to take responsibility for. And I fail to understand why what we adopted in 2023 on the basis of in-person testing is suddenly no longer able to sustain that. That is why I'm going to vote against any increase because I have not seen that analysis put before me. Thank you.
Thank you. Trustee Tony. Trustee Parhana.
Yeah, I think I'm sort of in alignment here with Trustee Tony. So a couple of things, I guess, and zooming out to what Trustee Sowell was mentioning, is there other sort of, can we find other revenue and other funds or cost centers that could offset this issue of the $600,000 gap?
So really the suggestion to go with option one with the 150, which would give us about $600,000 in additional revenue, it's really just to bridge the gap. Yes, there's still reserves to get through 2025, and there's reserves that will likely get us through 2026. Almost depleted, but it will get us through 2026. The general fund is the only fund that is unrestricted, where we could potentially, like I said, borrow money. The general fund, as the Board of Trustees knows, has also not been in a good financial position in past years, but there's reserves there that we would probably loan, and eventually the general fund, the admissions fund would have to somehow pay back. The remaining funds are all restricted, and we would have to do, it depends, right? Most of them are grant-related funds. I don't know that we could tap into them.
Okay, that's helpful. And I guess, I think similarly to Trustee Tony, it does feel like we're putting the increase on the test takers. And I think I operate from the mindset of if we're going to run a structural deficit, is sometimes a planned structural deficit. And at this point, it was forced a little bit, right? So I'm curious if we could move forward with an annual CPI increase that feels realistic over time and operate in a structural deficit, eyes wide open, and potentially leverage some of the general fund dollars. Could we move forward in a way that sort of maintains sort of a focus on ensuring our reserves are moving in the right direction, but B, also respects the fact that applicants having, these really large increases is just, it does not feel equitable or fair to me. So I would also not support this fee increase as it stands. I think there's a little bit more to do here in terms of other ways we can offset this this gap.
This is Erica.
Thank you.
Oh, I'll
Two
go
things
after
I'd like to.
Yeah,
Go
there's
ahead, Erica.
it's hard for us to raise our hands in the room. I think Trustee Gore has a comment as well. But two things I just want to briefly point out is that if we are not borrowing from the general fund, so if we are truly relying on admissions fund fees to support the bar exam, many of those fees are applicant fees. So if we increase a different fee that is not the bar exam fee, it could be the moral character exam fee and so forth. So I just want to make sure that that's understood, and I think it is, that many of these fees, if we are looking at them come later this year after September, will be those that still impact ultimately test takers. There are, of course, other fees within the admissions fund related to multi-jurisdictional practice attorneys and so forth, PLLs that we'll get to momentarily as well, temporarily. So there are other fees, but largely we're looking at raising fees, if not for the bar exam, still those fees that could impact test takers. So I just wanted to make sure that we are all aware of that. And then as you've heard from RSLE, the general fund is in a better circumstance than it maybe we thought it would be, but it's still not in a great circumstance. What I think we should be looking at, perhaps related to the admissions fund, is what the actual inflation rate is for the bar exam. Because as we've seen, the CPI, the 3% CPI, is not reflective of how much in-person test taking costs. We are seeing numbers that are much higher than that year over year to reserve exam spaces and so forth. So that's perhaps something that should be explored for this particular fund going forward, so we can have some of that information for you at a future meeting.
Thank you, Erica.
This is Deborah in San Francisco. The timing just couldn't be worse in terms of, we're trying to make a prudent business decision right now. But the narrative is going to be that the leadership of and I'll just speak for the trustees, botched this, and the attorneys are paying the price. Now, we know we're trying to make a decision, but given, all the troubles that we've had this year, you can see how we should be prepared that that's what it's going to look and feel like.
And if I could jump in, it seems like there's a significant interest in moving the direction of having a remote exam. We've seen the numbers and crunched the numbers about the remote exam being a cheaper option and more accessible and more fair and more equitable. It seems that's the direction that hopefully, in my hope is that we're heading. If we head that direction and we are able to reduce the cost of administering the exam, we're not going to reduce the exam fee. We're not going to go, oh, okay, we increased it by 150, but now it costs us less because we moved to a hopefully remote in 2020, whatever it is. So now we're going to reduce it. We're not going to do that. And so I would be remiss to agree to an increase when there's a potential solution if we wanted to take that option in a few years. And it's not ideal. It's not great. And obviously, if it didn't, I think if it wasn't at the time that it is now, then maybe we would be in a different position. But right now, we just had the February exam. That did not go as planned at all. We have examinees who have lost trust in the Committee of Bar Examiners and the Board of Trustees, and then we're going to try to hit them with another increase. And I just don't see how that's going to be positive in any sense. So I think my question would be, what happens if we don't? If we don't increase, we run it all the way up, and we kind of run into that endpoint of the reserves, what happens then? And maybe that's just an ignorant, not non-knowledge on my end, but do we go bankrupt? Like, what happens if we run out of money?
So I'll start, and Araceli can support me on this where I falter. Couple of things in response to that. First off, we have been saying if we were to go to a remote exam or do whatever with the exam and it ends up costing less, we would reduce the cost, not retroactively, but going forward, right? And that's part of why we do this exercise of trying to align the expenditures and the revenue. And we might want to have revenue a little higher than expenditures for a period of time to build up the reserve to the appropriate level that the board determines we should have the reserve built up, depending on what's coming, right? If we're going to be doing an exam development effort, that was one of the things that we were going to be doing with this surplus that we had originally projected for 2025 and going forward, is we'd be using the reserves to help develop the new exam. So we'd have the funding for that. And then once that was done, we potentially would have the ability to lower the costs. But I also, we operate in a world where everything that we do in the Office of Admissions is supported by the admissions fees. And the bar exam being the highest component, the largest dollar-wise component of everything that we do. So the fees that we receive are what pays the staff, are what rents the exam sites, are what pays for the proctors, et cetera, et cetera, et cetera. And we have been and will continue scouring the budget to figure out how to have efficiencies that we can reduce costs, because the answer is never just increase revenue. You have to look to reduce costs. But when the bar exam is such a huge proportion of the budget, if you're not going to reduce the cost of the bar exam, it's going to be very difficult to find other meaningful cost efficiencies that will meaningfully reduce the cost. And so if we, and this background is in part, like, we don't get money from the state general fund, right? So we can't run the reserves to zero, have a structural deficit, and continue to operate, right? So if we get to zero, if we have nothing in the reserves and we have a structural deficit, then we have to lay off staff. We have to do something very, very different, absent getting, a loan or something from the general fund. There may be some limitations, some legal limitations on the ability to use the general fund. We're looking at that, but there also may be political ramifications to using the general fund, right? These are fees that that licensed attorneys are paying, and we have other fees that are paid by those who are seeking to be licensees. And so there are challenges. And so, yeah, if we run out of money, we've got a structural deficit and no reserve, then we've got limited options. And so, we were able to sustain a structural deficit for a while because we had a lot of reserves and we were eating down the reserves. And so we could sustain that deficit. We could continue to subsidize various programs. Even back in 2023, we talked about the fact that, and it's a small amount, but we do still, we don't charge law schools the full the fee that would generate revenue that equals the expenditures on the law school programs. And part of the reason that the board and committee of bar examiners didn't ultimately wanted to continue that subsidy is because those fees also would ultimately fall on the students. And so, anything that we're continuing to subsidize is going to eat into the reserve. And so it's a challenge. It's a real challenge that we have to face because there isn't a magic pool of money that we have access to, and the focus on efficiencies is hard if we are going to continue with a really expensive way to administer the bar exam.
I know Trustee Trio's hand is raised, but are there any other trustees who would like to comment as well? I can't really see who's in the office. Alan, you can help. Anyone else in the LA office or in San Francisco office?
Nobody in LA.
Or San Francisco.
Okay. Trustee Trio, the floor is yours.
Thank you. I just would like to add a little context from my perspective. I know that we had these discussions about the initial raise back in 2023 of the fees. And even then, I think I speak to Donna's point here, which was that we were always on the brink of operating on a structural deficit. So even with the fees being raised at that time, from an operating perspective, it was still going to be difficult for us to make some of the basic make our basic obligations. In fact, we started selling our assets. We sold our property in San Francisco, which was a meaningful property, and regrettably, it only buffered us for another year or so. That said, I think that I've said this before, that we operate like an organization in distress. And what that requires then is it requires for us to gather our stakeholders together like we're doing now. And I think that we've gone to things like the general fund before, but we also need to have a very serious plan as to how we're going to get out of this mess, right? I think that is just, having worked with distressed companies in my professional life, I think that's the beginning. We need to find leadership that's going to help us do this. And that just, I wanted to give a little context. I'll just leave it at that. Thank you.
Thank you. I understand we have a resolution, but I'm not sure if we have the appetite or we're ready to prepare to vote on this resolution, at least among the CBE members. So with respect to the CBE members, is there any appetite to take a vote on the resolution, or do we believe that the staff would still have to do a little bit more work and explore additional options so that we can understand a little bit better about where the money can come from before we vote on this resolution? Any comments or suggestion?
I'm ready to make the motion for the immediate action.
I'm not sure. Oh. That was Dr. Bolton seconding.
Okay. Thank you. So Mr. Kramer moving, second by Dr. Bolton.
Sharon, that's the wrong resolution if you want to go to. Oh, sorry.
What is?
No, it's
2.4.
It's the right one.
It's the right.
So the resolution is as follows. It is resolved that the Committee of Bar Examiners recommends that the Board of Trustees increase the application fee to sit for the bar exam by $150 for both non-attorney and attorney applicants from the current $850 and $1,500 fees respectively. Any discussion or comments?
Would it be appropriate to just add a sense of the committee that staff is still asked to continue searching for efficiencies, savings, ways to reduce this burden?
Mr. Yokoson, I believe that sounds like an amendment. Since Mr. Kramer made the motion, I will have to ask Mr. Kramer, is this a friendly amendment acceptable to you?
Yeah, and Alan's a friend. I'll accept it.
Then Ms. Hertzkowitz, we will have to have that language in there.
And we have to ask the second, I suppose, too.
I'm sorry, it was.
And further, that staff be directed to continue searching for cost savings or make cost saving efforts.
To investigate cost saving efforts.
There we go.
I make a suggestion. I want some language about perhaps payment or installment plans that would help mitigate the burden on applicants. Would that be acceptable?
Yes.
So
Mr. Kramer?
One of the challenges with the installment plans is it may take more staff to administer installment plans. I'm going to defer to Araceli on that, but
And the programming.
Well,
right, we'd have to program our the admissions information management system, In order to accommodate that, we need to be able to track the payments, and then but allow people to register for the exam after only having paid X amount. So there may be a trade-off there. It may, if we have to hire more staff for it, then it makes it more expensive, which offsets in a negative way the benefit of the installment plan.
That-
This is why,
That may well be the case, but we'd like to at least explore it.
right, I think this is part of the cost benefit analysis that we want to do internally, trying to understand how much would it cost to implement something like this. Obviously, if you may be right, Ms. Hutzkowitz, but I think the committee wants to understand the ins and outs before fully, devote themselves to a specific resolution.
So that would be then for the next increase, for the more comprehensive analysis that we would bring to you in November. Is that right?
I think that's, Donna, I think what we're hearing is that it would be to explore the feasibility of installment payments in the same way that we'll be exploring cost savings going forward. So my understanding is without the expectation that would be implemented with the increase for the October 1st registration for the February 26th bar exam.
Can I also make a suggestion of changing investigate to explore if the individuals who made the first motion and second and the friendly amendments are amendable to that?
Mr. Kramer, is that acceptable to you?
I have so many friends right now, yes.
This is Julianne Smith. I just have a question about how feasible cost savings would be by if we defer this to September. I know, Donna, you had mentioned before that you did kind of like a pre-announcement in past years where we can kind of give notice to applicants that, this will probably be the full, amount, just so they know about it. So we're not, taking time away from applicants to prepare for a potentially higher fee. But if there are some realistic cost savings that the office can find, or maybe realistic options that were discussed already, like borrowing from the general fund, if that's, something that we should defer the final decision until September, do that notice they had done in previous years about the potential, probable increase, but then defer a final decision until September if there's something meaningful that could be provided at that time.
I see these efforts as taking much longer than that. And we won't meet in September to be able to hear the information. I don't think we want a special meeting just for this, so I would not accept that amendment.
Thank you, Mr. Kramer. Any additional amendments? Hearing none, Ms. McFarland, please take roll.
Bolton,
Yes.
Cow, not present. Gongora,
No.
Kaplan, not present. Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla,
Yes.
Montgomery, not present. Peak,
No.
Silva Guzman,
No.
Smith,
No.
Reyna, not present. Reyes,
No.
Yokelson,
Yes.
Chan,
Yes.
there are 5 yeses and 5 nos. So the motion fails.
Thank you. Back to you, Chair Stallings.
A tie.
All right, so with that motion failing to be passed by the Committee of Bar Examiners, is there a need for a motion by the Board of Trustees at this time?
If there
Since
is,
there's no recommendation, since there's no recommendation from the CBE, there wouldn't be any motion for the board to vote on.
Well, okay, give me 1 second to check because our board policy does speak to the tie votes. And I was trying to confirm that really quickly, but in the meantime, the board could take up this item separately on its own motion.
Agreed.
I'll make the motion.
All right, and Trustee Harrison, would that be with the added language that was added through the amendment process?
Yes.
Okay.
But, oops, I didn't mean to do that. Let me add it here, and then take out the adopts the recommendation of the committee of bar examiners. Oops. Does that work?
Wait, does that include the prior language about looking for alternatives?
Yeah.
Okay. It looks different on my screen.
Give it a second. Can you hit refresh, Devin?
Yes,
Sharon?
let me try. I believe there's a lag. Resharing. There we go.
All right. I'll make the motion on this language.
And let me just wordsmith it
Okay.
so it reads correctly. Okay.
Okay. This is good for me, Chair Stallings.
Right, is there a second? All right, I'll second. All right, any further discussion, or may I have a roll call vote? All right, hearing none, can I have a roll call vote, please?
Barahona,
No.
Buenaventura,
no.
Cisneros.
Aye.
Sorry,
Aye.
was that Good, not present? Gore,
No.
Grande,
No.
Harrison,
Aye.
Huser, not present? Sowell,
I'm a no.
Stevens,
Aye.
Tony,
Nay.
Trejo,
Aye.
Stallings.
Aye.
With 5 ayes and 6 nays, the motion does not carry.
All right, well, as discussed, I'm sure we'll be hearing more about this at the next meeting. Okay, we're going to move on to item 2.5. This is discussion and action, if appropriate, on provisional licensure programs, past and future data collection efforts. And this is being presented by our principal program analyst, Lisa Chavez. And definitely mindful of the time. What's your estimate on how long this item will take?
Chair, it should be about 10 minutes. This should be a
Okay.
quick one.
So if we could promote Ms. Chavez.
Hi, good afternoon, everyone. I'm Lisa Chavez. I'm sure those of you who have known for many years, I used to be the director of the Office of Research and Statistics, and I recently made the move to admissions and supporting Donna and Audrey and the amazing team in admissions in all sorts of special projects, but in particular in outlining research agendas to really move the work forward. I'm going to share my screen and I'm going to keep this as brief as possible. And this is really a discussion item, but if you do have some action, of course, we will take it. So really the purpose of this presentation is for us to share with you the data that we've collected in the past on the provisionally licensing programs, and I'll just share with you some ideas we have for future data collection. So just as a reminder, we have 2 programs in place right now. One is here at the top for these 2020 graduates. Around 912 participants. And their major requirement to license is to become licensed to pass the bar exam. Skipping down here, we have a pathway program that was put in place in 2021. We have around 1,000 participants in that program, and this is for a set of applicants who had previously scored below between 1390 and 1493 on a previous bar exam. And if they do 300 hours of legal practice and fulfill other requirements, they can be admitted to the practice. And as you know, we now have a forthcoming program, which we're calling the February 25 PLP program, established again in response to the February exam. It's really eligible for the people who were first-time applicants who either failed or withdrew from the exam. We estimate there's going to be slightly more than 1,000 people eligible. We've learned that half live in California and half live outside of California, with 28% living outside of the United States. So just to give you an example of the type of information we can collect, we know about these different cohorts and the types of analyses we're doing. What you see here is just like some basic demographics. And I'll just go ahead and skip through these slides very quickly and we won't go through them. But the types of analyses we're thinking about is like to explore the diversity of these different cohorts. Here's our original one, our original pathway, and then here are the 2 different groups, because we're also interested in comparing our set of eligible people for the February pathway with those who are ineligible. And the biggest takeaway you should take right here is that, women are the majority of all our different cohorts, including the possible future cohorts. But here on the right, you see a lot of differences in age, which really wasn't so surprising. But let me just go ahead and just continue on, and let's just get to, say, for race ethnicity. Again, we see a lot of interesting differences across our different pathways. But one thing really stood out right here, which is like for our eligible candidates, Latinos were 10% and African Americans were 6%, but they were higher in representation of those who were ineligible for this program. And then finally, we've been exploring a law school type, the types of law schools we're coming from. And one thing we just to keep in mind is that not all applicants are categorized according to their law school type. We only categorize law school type for our non-attorney applicants. For people who are already attorneys, we don't capture their law school type. And what you should take away here is that the majority of people who are eligible for the program are actually attorneys and who are current attorneys or other types of applicants. And this is really aligned with that residency data I shared with you on the previous slide. Well, let's get started really about the outcomes. We're really excited about the outcomes that we were able to really track for our previous programs. And what you should take away from this slide is that the majority of participants, whether they were in that original program or the pathway program, have been admitted to the state bar. As you can see, 80% of both have been admitted. We're able to do some analyses on those that are currently active in the program and to really uncover the reasons what is preventing them from moving towards license. And here, for example, of this original pathway that needs to pass the bar exam, we know that 78% have taken the bar exam more than once and have not passed. 15% have not attempted the exam. Down here at the pathway, we have 126 who are still active out of that original 1,000, and 18 actually recently have now met all requirements and they're waiting admissions. But still, we have a big group of the majority of 126 who just haven't done all their 300 hours and done other requirements. In 2022, we did a survey of those original and pathway participants, and we learned of them and their supervisors, and we learned that there's very high levels of satisfaction that they experience. Not only satisfaction, but benefits they saw to the program. I'm just going to go ahead. But we also learned of different challenges that people faced. The biggest challenge that the participants was they felt that explaining the provisional status was awkward. Down here, that original cohort that has to pass the exam, they said that it was studying for the bar exam was very difficult along with their work. And their supervisors here, around a quarter was kind of consistent, but they found that when they compared those PLLs that they were supervising compared to newly licensed attorneys that they had worked with previously, they felt that, some needed more supervision, they were unable to handle similar work, and some needed new training. But again, this was in the minority of all supervisors who were certified. But what I want to draw your attention to, and this is something that has been come up and we're going to talk about it in the next slide, is that it is how people are really experiencing, if anything, negative experiences. And here we saw that, 4% of PLLs felt that discrimination and harassment challenged them to a small extent, and 2% to a great extent. However, some external researchers said despite this small group, and this is of course significant, if you add this up, it's 4, 3, and 2% saying that they did experience discrimination and harassment. Ultimately, this group of PLLs really still supported the program. They really recommended the extension of the programs, and they have the same level of satisfaction as others. We did an analysis of the extent to which people were paid or not for their PLLs. As you know, people can participate in the program on a volunteer basis and not be paid. And we found that the majority were paid, but still 24% were not paid. We found that there was a difference in gender, so women were more likely than men to be paid. We also found variation by race, ethnicities, and Latinos were more likely to be paid than white and Black PLLs, but really the greatest disparities were among Black PLLs, where less than half were paid. And then finally, we saw an incredible difference here across age. Whereas the majority of our youngest PLLs were paid, 84%. For our PLLs who were 56 and older, only 39% were paid. So what are we going to do to support our PLLs going forward? I'm excited to share some thinking we have right now. So first, we've decided that we're going to establish a dedicated email address where PLLs and their supervisors can share concerns, challenges, and feedback of their experiences. This is not going to be a formal complaint process. It's more intended for the Office of Admissions to listen, learn, and identify patterns of systemic issues. Here on the right, we have a Council of Access and Fairness, and our Office of Access and Admission is going to, our Office of Access and Inclusion is going to work with COAF to identify resources that promote a productive and supportive experience that will benefit both parties. Here on the bottom, we are talking about working with COAF to improve and expand the survey that we plan on doing. Again, that's similar to the survey I just described. I've taken a look at those questions, and I think there's a lot of ways we can improve how to really get at issues of discrimination and harassment, and really just more targeted questions to those unpaid PLLs to really learn more about this experience. And we've already started these conversations with COAF. And finally, we're going to facilitate collaboration between COAF and the Legal Services Trust Fund Commission to support PLLs who work in legal aid. So the last slide I have right here is some ideas that we have for future reporting that we'll be reporting out to the CBE and the Board of Trustees throughout the year. First, here at the top, of course, we're going to be looking forward to sharing out with you what happened with the applications. Again, we had 1,000 eligible. In the end, how many eventually applied, how many were approved, and this really get at demand and access. We're going to really try to understand the reasons why applications were not approved, and we're also going to explore reaching out to people who didn't apply to understand why they didn't submit an application. And then we also going to, of course, report out a new application processing time, because we're really committed to doing that. We actually have a metric to track this regularly. And then once we seed our new cohort, we're going to continue on with the analyses that I described before, really, again, talking about outcomes, to what extent people are being admitted, who's still admitted and terminated versus suspended, sharing out with you all the status of their progress towards licensure, given all the different requirements for the different cohorts. Again, we're going to work with COAF to learn more about their experiences, surveying PLLs, their supervisors, and again, we'll plan to share out with you anything we learn from that special email address that we're going to have regarding any placement concerns. We'll share out a number of inquiries and a kind of a summary of the themes, maybe, and actions that we've taken. And then finally, once for those who are admitted to practice, we'll share out with you, kind of the average time from program start to full licensure, and also engagement with the discipline system. We've already also started some of those analyses as well. Okay, so given everything we shared right now, we're interested in knowing if you have any particular strong interest in some data points, analyses that you would like to see about these 3 different cohorts that we will be tracking. Thank you.
All right, thank you, Ms. Chavez, for that comprehensive yet brief report. All right, any questions or comments?
It's Julianne Smith here. I think it's, this program is an interesting way to maybe test other ways we can do admission tests if we want to do some kind of supervised practice as part of, new attorney admissions. So using this data, to inform maybe how we do that, how we do an admissions practice in the future. I'd like to maybe have more detail on the gap that some supervisors are seeing between the PLLs and newly licensed attorneys. I think some said they, need more supervision, need more training. So I would like to see kind of the details, like what is kind of missing there that they would like to see more training in, that we could kind of think about as far as, developing something, as far as admissions goes in the future. What are we looking for as far as what they need to know?
Thank you for that.
Mr. Chair, this is Bethany.
Please.
Thank you. Regarding first of all, thank you for that wonderful presentation, very informative. Regarding these data points about paid versus unpaid, do you have any information about whether those were like public and private sector, and like which of those is more likely to pay and which is not?
Actually, it was interesting. Unfortunately, that survey item, what sector people worked in, a lot of people skip that question. So we will have this information going forward, because that is actually captured on the application. The analysis I shared was part of a survey. So moving forward, we will be able to present out on whether or not there's variation by sector, because that's captured whether they are paid or not, and their sector is captured on the application. And those are mandatory data fields.
Okay. And then my second point, last point, is just are there any outreach efforts to, currently licensed attorneys and firms regarding the PLO program, providing them information about it and, kind of encouraging them to participate? And I bring that up because I saw the point about some attorneys feeling like secondhand citizens or secondhand attorneys, right? And I could see that. In my mind, I'm like, I'm at a law firm right now. My law firm is minority owned, and we make it a priority to try to bring on interns and younger attorneys because we want to be able to, be part of the pipeline and all that. And this is something that, my firm, and I know many others would be eager to participate in, but I don't know if a lot of firms have information about it. And it's kind of scary to be dealing with someone that's like, I'm not actually licensed, but please let me come in. And so I just wondered to what extent we're reaching out to firms and licensed attorneys right now about the program.
Not to step on Lisa's presentation, but yesterday, Tara Clark and I, who from being on the CBE, she works with me in admissions, we did a webinar info session for law schools to talk about law career services and helping with placement. We're going to do an info session webinar with California Lawyers Association, and we reached out to a large list of affinity bar associations about this program starting in, applications opening in September. Anything else in terms of outreach that board or committee members want to send to us, that would be great as well. But we are trying to do outreach efforts on our end to help provisionally licensed lawyers get paid placements.
Okay, lovely. Well, I hope Lisa comes back to the committee in maybe a year and gives us another update, because I'm a huge supporter of the program. And, as a committee member, I want to be involved and make sure it's a success. Thank you.
Ms. Chavez, in looking through the slides, one number jumped out at me, and that's, I believe, on slide 7. And that number is 97% have not submitted a PLL evaluation. One, why is that such a high number? And two, what number does that translate into? 97% is a high number.
It is fine. Okay, Audrey, could you speak more about this? But I think it would be the last step in going through the process, and so I imagine it's the last step. So
it might be conflating something, Lisa, because 2020 graduates don't submit that. It's only the pathway. So I don't know if it's conflating some of the requirements.
No, this is just for the pathway.
It's just that that's the final requirement. So anybody who's still in the program, once they've done that, then they've done everything that they need to do, and they can move on to being admitted. So you don't do the evaluation until after you've gotten the full 300 hours. So anybody who doesn't have 300 hours is not going to have an evaluation. Right.
Those statistics that we're hearing today do not capture comments from that 97% population. Am I understanding this correctly?
So out of the people who have yet to complete their 300 hours, what I think you said it was 126, they have done that because they haven't finished their hours.
This is
So
not
90
this is not an evaluation of their experience in the program. This is like a separate requirement to pass out of the PLL. Is that right?
That out of the pathway, yeah.
Okay, thank you.
All right, trustee Tony.
Thank you. I was very impressed to see the high numbers of PLL participants who have been admitted. I think it was like 80%, 81%. And I was curious, what was the goal going in? You know, the 80% sounds really good. I'm presuming it wasn't 100% because that would be not a very realistic goal. But how close does 80% come to the goal?
Not aware of any goals.
In terms of the rules, there weren't goals, I think. So I think there weren't goals set about how many would license, but I think that it is a wonderful figure to report out.
Thank you.
So just to clarify here, this is Erica again. Trustee Tony, you're referring to the passage of the pathways group or the general PLL population?
I saw 80% is what I saw as the number that have been licensed.
Sure. So this is from the original program, and I think some context is helpful here. So these are the individuals who, as you'll recall, during COVID, were not able to take the exam in the first instance. So I think the general goal is that all of those, like we have, is that anyone who takes the bar exam will ultimately pass the bar exam. And that's what 80% of those who were not able to take it, at least at the beginning of when this program was issued because of COVID-19 at the time, has ultimately accomplished. But I do agree that I think that these are very high numbers overall, you know, compared to our typical passage rates as well.
Right, any other questions or comments? Okay. Seeing none, no action is necessary on this item. Is that correct? All right. Perfect. Well, a crowd favorite here today are discussions on fees. So that's why I'm going to hand it back over to Alex to take us through 2.6.
Thank you, Chair Stallings. Agenda item 2.6, which is the discussion and approval of the 2025 Provisional Licensure Program fee. I believe Ms. Montoya Chico and also Audrey Chang also have a presentation for us. If so, please take it away.
I'm going to take it away first very briefly, and Lisa was helpful covering some of those eligibility requirements because I'm just going to talk about the changes with the provisional licensure program that for the February 2025 cohort. So this is from this webinar we were doing with the law schools yesterday. Lisa mentioned this as well, but same with the 2020 graduates, the February 2025 cohort has to pass a bar exam to license. Some of the requirements of the February 2025 cohort that's important to note because it's an accelerated timeline. So you need to apply, the application will open September 1st, and you have to apply between September 1st and December 31st. Requires that you have a supervising lawyer. You have to pass the MPRE by the end of this year, which is important because there's only one more MPRE available within the time frame between now and the end of the year. You have to have a positive moral character determination by the end of the year. You have to have that supervising attorney that's committed, states that they're committed to supervise you through the end of the program. And then you have to also complete the new attorney training program by May 31st of next year or within 5 months, whichever is earlier. So that's just an accelerated timeline for those interested in this program. Similar or really exactly the same as the 2020 cohort. It's a pretty broad list of allowed responsibilities. You do have to state that you're a provisionally licensed lawyer. Your supervising lawyer has to have their name and information on your documents. And then again, under supervision, you can do a variety of different legal work, appearing before court, drafting legal documents, engaging in negotiations, settlement discussions. And then anytime you need to change supervisors or one supervisor is terminated and you have another one, you need to report that immediately to us. I think that's all I'm going to share in the interest of time about the changes with the PLL cohort Feb 25. Was there anything else you wanted me to share, Araceli?
No, I just wanted you to kind of share a little bit of background on the program. So now I'm going to jump in on the actual fee itself. And as Audrey just mentioned, the program is due to open September 1st. So we really need to make a decision today as to which fee we are going to charge for the program. As we've discussed earlier today, the State Bar does charge a fee for all of its service programs, and the goal ultimately is to try to cover the cost of the programs, although that is not always the case. The language in Rule 9.49 for this program does allow the State Bar to set an appropriate fee that is meant to cover the cost of implementing and administering the program. So I don't have a presentation, but I will share the Excel file where the three options are modeled. I just want to really quick run very high level through the methodology that we use anytime we assess any of our fees, whether it's in the admissions fund or otherwise. And on page 3 of your agenda is where I briefly highlight the methodology that we use to come up with the fee. And there's 4 components here, which is first to come up with the expenses that we expect to incur in any given program. First, we have the employee costs, which encompasses all of the employee salaries and benefits, and that's the staff, and that's the amount of staff time that will be devoted to this particular program. So whoever is meant to work in this program, we compile all of their salaries and benefits, and that's a component of the expense itself. We obviously include the indirect cost at a per employee basis. So again, similar to the employee costs, which employees are meant to work in this program, and we compute an indirect per employee cost, and that factors into another expense component. There's also what I'm calling external expenses, which some programs may or may not have it. And this is primarily if there's temporary employees that are part of the program, or if there's professional services or supplies, those sort of external expenses. And then finally, for this particular program, the counts. The counts are a critical driver to determine what fees are going to need to be to cover the expenses. For this particular program, we've compiled what we anticipate the fees to be for the entire term of the program. So starting September 1st, and it ends on December 31st, 2027. So you see in attachment A, the expense doesn't change in any of the 3 options. The expense is what it is, and it's really the counts that are driving the revenue that we need to earn in the various options. So let me just make sure I want to share. I'm going to share my screen now, so please let me know when you see it, and it'll be the Excel file of the options, and I'll run through the assumptions for each option. So hopefully, is it up? Can someone let me know?
Yes. Yes.
Great. So these are the 3 here. These are the 3 options that I am presenting in the agenda. I will really quick before I get into all 3 of them, I will add, again, the costs, as you can see, remain the same for all of the 3 options. That's consistent. It's really the counts that are going to drive the difference. I do want to highlight that there's the portion that says unpaid volunteers. Those are all we're making the assumption that there will be some folks that are going to be unpaid, and those obviously we unpaid volunteers that will not be obviously charged the fee since they don't get paid. So that's that particular one. You also see here a line item for what we are calling the IOLTA applicants. These are the individuals that may work for IOLTA funded organizations, and we have historically offered a discounted fee to these to this group. We made the assumption that we would charge 50% of whatever the fee in the whatever the regular fee for applicants is. So that's where you see the fee will always be 50% in the 3 options. Again, the counts, it's similar to what we had seen in prior cohorts, but the counts it's our best guess. So let me run first through the first option. The first option is all of the applicants that are all of the eligible US-based applicants. And this is the 729 of all US-based applicants that could apply for the program. As I mentioned, there is a portion, the 182 that we, which is roughly, and Audrey, I think you had a comment on this, which is roughly 25%, which is what we've seen historically based on a survey.
Right.
Yeah, so, historically, we've seen in a survey that about 25% are unpaid. So I extracted that amount. If we assume that 729 is our total universe of the US-based applicants, and then 25% of that is, we expect them to be unpaid, that's your 182. So now that leaves us really with 547. And I did try to break it out in table 1 of the agenda, kind of the counts to see if it'll help with the number reconciliation. So we have 547 of fee-paying PLLs, and that again was split between IOLTA, which we set a count of about 75. So that means that 472 would be what we're going to call normal applicants. And again, we're trying to get to cover the cost of 609,000. So in order to do that, the fee would have to be under option 1. For normal applicants, about $1,200, and for IOLTA, half of that, $600. So that's option 1. Option 2, we basically said, what is 729 is the total eligibility pool, but is every single one going to apply? Not likely. So we added a reduction and assumed that about 70% of applicants would apply to the program. So as you see here in my column N, we basically just applied a 70% participation to the accounts in option 1. And that gives us these new counts in option 2. The total would be 510. Again, 25% of that would be 127 unpaid. So there is no fee for that group. Again, the 70% for IOLTA and applicants are the numbers you see here. And those are the pool that would pay the fee. Obviously, the lower the count, the higher the fee to try to cover the costs, which is what, again, the goal is of programs that we charge fees for. With this lower count, the fee is higher, so it would be about $1,700 for a normal applicant, and half of that, $885 for the IOLTA applicants. Option 3 is based on the 2025 mandatory fee, the licensing fee, but it excludes the client security fund. So the fee, and again, the counts, we made the same assumption that about 510, which is a more realistic count, that's what we're going to base it off of. The fee itself, the mandatory fee is $551 for 2025, and this does not include any of the opt-ins or opt-outs. We completely excluded those. And the reason why we also excluded $40, which is the client security fund portion, that's because the rule 9.49 subsection F, it expressly prohibits PLs from accessing client trust accounts. So we deemed that it was appropriate to eliminate that $40 portion, and that gets us to the 511, which you see right here. Half of that for IOLTA would be about 256. This is the only option that, as you see, does not cover the cost of the program. That only generates about $182,000, meaning that it leaves about $427,000 of deficit should option 3 be selected. I know it was raised in one of the public comments that this is significantly higher from the original program, which is $75 for normal applicants and $50 for IOLTA applicants. And we do acknowledge and we recognize these fees are higher. I don't have the background of how those numbers were derived, but I can tell you that they did not, even at $75 and $50, cover the cost of the program when it was first implemented. Is there anything else? If the CBE and the board selects either options 1 or 2, or two particularly, if we determine, once the numbers come in, that the participation is actually a lot higher and the fee should be lower, certainly the CBE and the board could consider offering reimbursements to applicants based on what the fee difference should be. If the participation rate was, say, 90% instead of 70, since theoretically, not theoretically, the fees would be lower if the participation were to be higher. I think that's all I have for the 3 fee options. If I can answer any questions or comments.
This is Alan in LA. It's probably a stupid question, but from a government lawyer, what is an applicant, excuse me, an IOLTA applicant? Is that somebody who wants a trust account, a client's trust account, or what is that?
The IOLTA is the interest on it. Oh my gosh, how am I? Interest on lawyer
lawyers.
trust accounts. Yeah, and we do offer grants to what we call IOLTA funded organizations. And I think this group particularly, it's nonprofit organizations mostly. So we tend to offer, or we normally do offer discounted fees for IOLTA funded organizations. Attorneys working under IOLTA funded organizations. Yeah.
Thank you.
This is Erica. Just to, we did hear public comment this morning that asked that this population be, or this fee reduction be expanded to those beyond the IOLTA participants, because there are other programs, you know, legal aid organizations and so forth that do not receive IOLTA funding, but arguably would have the, you know, same cost challenges to hire, if they're going to pay the fees for that PLL, to hire the PLL by paying their fees. Or if they want to, you know, hire a PLL who is paying their own fees, they're concerned that this could, these high fees could discourage participation in the PLL program.
In the current program, the IALTA organization pays the fees for the applicant.
And as a reminder, we have to have a fee approved for this program today, even if it's not one of the three options proposed.
Yes.
Yeah.
With that, any additional comments?
Yeah, a couple
questions. Go ahead, Mr. Kramer.
It looks odd to me that the indirect costs are higher than the direct labor costs, but I guess that's just the expenses of the bar. Question though, so this is an application fee paid once, correct?
It will all be paid up front, correct?
Okay, and then in the roughly, what is it, 2 years they could be in the program, they don't pay annual bar dues like licensed attorneys do. Is that also correct?
That's correct. This is a one-time fee.
Okay, so this is in lieu of the.
Yeah.
So.
The only other thing they pay for is that new attorney training. It's $55.
Okay, and this would be paid, this fee is only for the new participants in 2025? Okay.
Yes.
Yes, I hear.
Yes, I believe so, yes.
Okay, yeah, well, you know, this is I guess a tough one. The people who are volunteering, are the unpaid volunteers well, they're not getting the value of a salary or any kind of compensation. They are getting the experience. So I could see charging them a little bit. Under option 2, the 1,700 is probably not that different than if they were licensed. It's a little bit more, and they were just paying normal attorney licensed attorney fees. There is a cost to get them in the program to verify everything. Yeah, I don't know if there's a good answer. I could go with either one or two, but I can't really justify leaving $400,000 of unreimbursed costs on the table, which is option 3.
Paul, if one of the things you just said was about charging the volunteers, we are not going to be allowed to charge the volunteer under the rule.
I'm sorry, one more time?
The unpaid volunteers, I think you might have said that we could charge them something because of the experience they're getting, but
the rule? Okay.
under the, yeah.
All right.
This is Jillian Smith. Just had a quick clarification. So the PL doesn't have to be in California, correct? Just the employer has to have an office in California. But I'm guessing there probably isn't any meaningful statistics on people outside of California who would want to be in this program.
We don't know yet from that breakdown of eligible participants that's why it's a little bit hard to set the participation, because we aren't sure really out of the addresses we have how many outside California or outside the US will be able to and want to participate.
What's the size of that population outside of California?
You know, Elisa was just had it on her slide. Let me just grab it one second.
I think I have her slide about 50-50. I think that's the breakdown.
Yeah, that sounds right, because the other two are about, yeah, quarter and a quarter, so that sounds right.
And then just for calculations, if we have the option 1 fee, but then 70% participation, what would that figure come out to?
So I think that's option 2, unless option 2 is the 70% participation.
Oh, I was asking for if it was the 70% participation, but we put that in the option 1, the 1,200. I guess that would be a deficit as well. If we offer the lower 1,200 and then we get only 70% participation, you know, we do option 1, but we don't get all of those, that would be running into a deficit.
Oh, okay. You mean if we had a 70% participation, but we wanted to keep the fee at 1,200?
Correct. Like what, I guess how much of a deficit?
Yeah, we would have about $181,000 deficit if we did that.
Thank you.
I'm just gonna revert it back really quick.
And that's coming out of admissions.
Yes, this is all in the admissions fund, correct?
In the interest of time, we'll take a couple of additional questions, but it sounds like option 1 is a safer option. But I will defer to the community bar examiners to see if there are any additional comments or questions.
Here, Chan, I just want to move over to Trustee Tony real quick.
Please. Yes, Trustee Tony, thank you.
Thank you. I'm going to ask a couple questions that I know Araceli will not be able to answer because she wasn't here when these, but if somebody was here and can help, when these fees were first adopted, were they adopted both by CBE and the Board of Trustees? That's my first question.
So I'll take these. I was actually staffing the working group that created the provisional licensure program. There was a special working group that was appointed that recommended the fees. They recommended the entire program, including the fees, to the board. CBE had 2 representatives on that working group, but the proposal did not otherwise go through CBE.
Okay, thank you. And the $50 and $75 levels, was it acknowledged at the time that that didn't cover the cost, or had the cost not been calculated at the time the decision was made? I'm just curious what the process was.
Yes, well, we were very clear that it didn't, I don't know that we calculated the cost, but we were very clear that it didn't come anywhere close to covering the costs. But the scenario we were in, right, this was, we were developing this program in August of 2020 in response to the fact that we knew that there were a number of people who would otherwise sit to take the bar exam who did not have the ability to do so because of the circumstances of COVID. They were, for example, you know, in an apartment with 4, you know, a 2-bedroom apartment with, you know, with 7 other people. There was no ability to study. There was no library open that they could go to, or they were you know, now the sole breadwinner for their family, and they needed to work and so couldn't take the bar exam. And so we intentionally, the working group intentionally set the fee as low as possible.
Okay. Now, the reason I'm asking is because this feels different from the last discussion to me. And this is one in which we are now looking at how to remedy past situation and how to right size the fee. And I can support the concept of right sizing the fee that was not right sized at the beginning because of the extraordinary unprecedented circumstance of the pandemic and, shutdowns and everything. So thank you very much.
Thank you, Trustee Tony. Anyone else? Well, here or none, we
Sorry, just a quick question. You're talking about doing possible refunds, I guess, if there is more participation than expected. What's the timing on that as far as when the PLs could expect to receive possible refunds?
Well, the application's only being open from September 1 to the end of the year, so we would know, and we'd be able to do it after it closes. I'm sorry to answer for you, Araceli.
No, yeah. So after the December period closes and we have all the data, if option 2, for example, were selected and the participation rate was higher, and the CBE and the board were both in agreement to do so, we would have the data. I would say January, right, Audrey, to be able to determine that.
It would be closed. We would know who was in the pool.
Would you have to program Ames?
To give the refunds, I think we could, I mean, we would probably have to do refunds outside of Ames, right? So, I mean, it would be onerous to do, but I think it would be worthwhile if we had a huge uptick.
I'm just thinking programming costs so much that would probably eat it all up.
Yeah, to give the refunds, I don't think we'd have to program anything. We'd have to figure out the dollar amount, and then it would be onerous in terms of finance and us working out how to do all the refunding back to the applicants, but it wouldn't be something that we'd have to program.
This is Deborah Gore in San Francisco as well. So if I'm looking at this correct, option 1, the 729, setting it at 1,200, that's 100% uptake, correct?
Yes.
So, okay, so then the 70% is the probability that that there'd be a 70% uptake. Do you have a sense of what the probability is when you offer the program, what the engagement will be, or the participation will be? Because I can't tell if it's like, well, at 1,200 there'd be a lot of people will be enthusiastic at that number and we'll be at 80%, or at 1,700 people will be all, whoa, that's pricey, and we have a 30% uptake. I'm trying to get a sense of where to put that number so that the market receives it well. You with me?
Yeah, yes,
Okay.
we've struggled with that,
Okay.
I'll just say, because we don't know. And obviously, the higher the program costs are, the less likely people will be to participate.
So this is our best guess.
This is our very rough
70%
best guess is
Okay.
yes.
Yeah, because
yes.
whatever you set the percentages, and we just do the math to
Correct.
set the fee.
And I think frankly,
Yeah.
my personal opinion is this is an over guess. I think there could be fewer than this, but if we lower the number, the fee goes even higher.
And the deficit gets bigger.
Correct.
Yeah, we received
you.
a fair amount of thanks for nothing comments when we recommended this thing. So some people are just not going to like it, regardless of the price.
I know we're running out of time, and so at some point we're going to have to start thinking about which option is best. If I may ask Ms. Chang to put up the current resolution.
Willing to make the motion for option 1, if that's where we're kind of leaning.
Yeah, we're going to have to have someone move on any of the options, and then let's see how that pans out before we decide whether to move forward with a different option. So here currently we have a resolution in place which says, should the committee bar examiners concur, it is resolved that the committee of bar examiners recommends that the Board of Trustees approve option blank as the fee to be charged for the 2025 Provisional Licensure Program. So with that, is there a motion on any of the 3 options?
I'll make a motion for option 1. This is Ashley.
Bethany will second.
Thank you, Ashley. Second by Ms. Peak. Any additional discussion or comments?
I guess when this is all over, a report about what actually the uptake was would be interesting. We don't have to put that in the motion, but we can calibrate our marketing.
Okay. Any additional questions and comments? Hearing none, Ms. McFarland, please take roll for us.
Bolton,
Yes.
Cow, not present. Gongora,
Yes.
Kaplan, not present. Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla,
Yes.
Montgomery, not present. Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna, not present. Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 10 yeses and 0 nos, the motion passes.
Thank you. Back to you, Chair Stallings.
All right, thank you. So with that recommendation from CBE, I move for a similar motion approving option 1. Can I have a second?
I second.
Second by Trustee Grande. Any further discussion, or may I have a roll call vote? Okay, seeing none, roll call vote, please.
Barahona, not present. Buenaventura, not present. Cisneros,
Aye.
Good, not present. Gore,
Aye.
Grande,
Aye.
Harrison,
Aye.
Huser, not present. Sowell, not present. Stevens,
Aye.
Tony,
Aye.
Treo, not present. Stallings.
Aye.
With 7 ayes and 0 nays, the motion carries.
All right. Thank you so much, everyone. This brings us to the conclusion of our open session items. We will be going into closed session. The board will not return, the board will return to open session business items in section 3 after it's closed, closed session items. And want for the record read that the board and committee will now move to closed session pursuant to Government Code Section 11126 sub E sub 2 sub B sub I and Government Code Section 11126 sub E sub 2 sub A to discuss conferences with legal counsel for anticipated litigation and existing litigation for both the Board of Trustees and the Committee of Bar Examiners consideration. The public should also be informed that closed session item 2.1 pursuant to Government Code Section 6026.7 sub C sub 6 and 6086.1 sub C will solely be for the consideration of the Board of Trustees regarding the request to waive confidentiality. After returning from closed session, open session business items in section 3 on the agenda pertaining to only the Board of Trustees will be addressed by the board. I really don't have a estimate on when we'll return from closed. So if you're a member of the public, just stay tuned to this station. So first to this this feed. And I understand that staff will be sending out closed session links.
Yes.
Have you done so? All right.
The link was just sent.
All right, we're going to adjourn into closed session and we'll see you on the other side.
Thank you.